Good morning, everybody. Before we start our public hearings this morning, if you would all please rise to join me in the Pledge of Allegiance. I'm going to open the public hearing for House Bill 59 and welcome Representative Mannion to introduce his legislation.
Thank you, Madam Chair and members of Criminal Justice and Public Safety. Representative Dennis Mannion, Rockingham 25 Salem. This bill here before you is similar to a bill that was filed last year by Chairman Roy. He had it in two parts. So he had one bill with this bill and the bill that's going to follow this. So I separated them into two separate bills. What this bill essentially does is add language in the RSA under first degree assault and second degree assault, adding a subsection talking about knowingly causing serious bodily injury to a public safety official. That would include law enforcement, paid firefighters, on-call firefighters, EMS personnel, in raising the penalty in the situation where it's a first degree assault to a Class A misdemeanor. And then in the section that applies to second degree assault, it would be knowingly or recklessly causing bodily injury or unprivileged physical contact to the same people, law enforcement officer, paid firefighter, volunteer on-call firefighter, or EMS people. So obviously in today's culture, there's a lot of anti-police rhetoric going on, and this is a way for us to protect our public safety people, not just law enforcement, but EMS and firefighters as well from assault while they're in the course of their duty. The bottom section of this bill talks about extended term of imprisonment. We added that this year because it will remove a similar section in that part of the statute. So there are certain crimes that you can petition for extended terms of imprisonment. This is one of them for an enhanced penalty. I think it's cleaner being in the sections of first degree and second degree assault because it clearly defines what the penalty should be in it. And for the extended term of imprisonment, there are some things you need to do before that applies. You need to obviously notify the defendant beforehand that you intend to impose that. So this just makes it cleaner. Thank you.
Thank you, Representative Mannion. Representative Paquette.
I just have a question. Does this encompass both municipal and private as far as EMS?
I believe it would. So if you're private EMS, and I don't know, there are some private EMS that also work for municipal agencies. So I would imagine it would apply to all EMS personnel.
Thank you.
Representative Lascelles.
Thank you for taking my question. Would public servants such as ourselves be included in that?
Not as I read it, no.
Do you think they should? Follow up, I'm sorry.
If you want to file a separate bill on that, but I think this specifically encompasses our public safety people who deal with this on a daily basis.
Thank you.
Representative Newman.
Yeah, I just have a question to follow on your question about the paid private EMSs and stuff like that. And whenever you have a list, you're apt to leave somebody out. And I'm wondering if a more inclusive phrase might be appropriate to say, like in first responders, for instance, list them. And so you'd get the people that are in the list and put some more inclusive term in there that maybe more broadly defines what those people do, so that if you missed one, you just don't have a list, you have also an inclusive phrase. I don't know what that would be, but maybe first responders would be it, or just make the definition be positions like, so that you're not limited to just that list. So
There is a list actually in the statute, but this language was taken from the existing statute under RSA 651-6, extended term of imprisonment. And it's subsection G that says almost the same exact language. And that list that's in current statute is the list that we used to create this bill.
Okay, thank you.
Representative Muse?
Thanks for taking my question. How does the bill address situations, and I know this comes up frequently, not just for EMS personnel, but for police and firefighters as well, but encounters with people who are either having a mental health crisis or who are under the influence of a drug that dramatically alters their behavior, like PCP or something like that?
So in the situation where it's mental health, this knowingly is a high standard, a culpable state of mind to reach. So if someone were to be charged with that, obviously that would be taken into consideration during trial. As far as somebody under the influence of alcohol or drugs, that's not considered a defense in New Hampshire for any offenses you're charged with.
Newman?
Thank you. And just to comment on that, these penalties are not mandatory minimums, so therefore I think in the mental case issue, the judge would have discretion not to assign a felony and take the proper action in sentencing. Do you agree with that?
That's how I understand it, yes.
Representative Prue, you good? Any question?
No, I'm thinking about jumping up in that seat.
Okay. Everyone set?
Let's see how this plays out.
Representative Newell?
Thank you, Madam Chair, and thanks for taking my question. I'm concerned a little bit, so I understand that knowingly would be, that would speak to the intent, but recklessly to me is a little more concerning as far as, I don't know, if you could comment on, what would be an example of recklessly? And also, I think that you would have to have some type of standard where, first of all, they know that it is a law enforcement officer, an EMS, or something like that. I think if they're not in uniform or not on duty at that time, but this still includes people who are not on duty at that time or in uniform, but the person would need to know that they are, that is the profession that they do. But then also to the idea of recklessly and kind of how that might play out.
As far as identification, you would have to know that it was a law enforcement officer or another public safety official for this to apply. But recklessly is a culpable state of mind just below knowingly. So it's purposely, knowingly, recklessly, negligently. So you would still have to have a significant state of mind that you know what you're doing is reckless or knowingly. And again, being under the influence of drugs or alcohol is not considered a defense for a crime. And in the case of somebody with a mental health problem, that's going to be taken into consideration, as Representative Newman mentioned. It's not a mandatory minimum, so that's something that would wash out in trial. And I assume at that point, there would be more concern with getting that person assistance than putting them in jail.
Thanks.
I don't see any further questions. Thank you, Representative Mannion.
Thank you.
Representative Prue?
Good morning.
Good morning.
Representative Mark Prue, Hillsborough 15, which is Manchester Ward 8. I've been in EMS. Some say I took Jesus off the cross, but that's not true. But I've been in it a long time, over 40 years. And yeah, I've been hit a bunch of times. And we always take into account, were they in a medical emergency? Or were they pissed off because I ruined
Hey,
their high?
Representative, you're on TV. You were angry, or they were angry.
Yes.
Thank you.
And they punched me because I ruined their high. Or some other thing like that. We got in the middle of a domestic. Recklessly, they're mad. They throw a bottle and it hits me in the face. Yep. That's reckless. and they meant to do it. They meant to throw it. Their aim was not as good as it should have been, but it got me, right? And I have one of my colleagues who will tell you her story of a deliberate action, and there have been plenty of deliberate actions. And when we point it out to the police, they go, yeah, we're not going to do anything because nothing will happen with it, so why bother? So that's what this is for, right? To give a consequence that if you hit police, fire, EMS, touch them without permission, knowingly, recklessly, or all the things, there should be a consequence. Otherwise, we're just open game. And it happens big city, small town, medium town. It happens everywhere. So I believe this is very important to put some teeth behind, hey, don't hit me. Right? And some people have been beat up pretty bad. If you remember in the Elliott, some guy has a brain injury and can't work again because he got beat up so bad. So it happens, and there needs to be a consequence to protect the people who are coming to help. And I would really appreciate your support in this. And I will take questions.
Thank you, Representative. Representative Murray.
Thank you, Madam Chair, and thank you for taking my question. I have two questions. The first is what you were just saying about the incidences kind of being dismissed and them saying like it's not going to go anywhere. Could you talk more to that? Like, are they saying like regular assault charges are just not going to fly as well because of your uniform, essentially?
The uniform, and that it was a misdemeanor, and where the bail was, they would be out before I completed my EMS run form within 24 hours. Just saying.
Oh, and can I do a follow-up?
Follow up, Representative Murray. Representative Knoll.
The other question was, I can't recall where the legislation went last year. Do you know?
Didn't go anywhere.
It didn't come out of this committee or this body?
I believe it was in the other side of the wall that
Okay.
didn't like it or something.
Okay, that's what I was.
All
thank
I
you.
know is there's still no teeth in me getting hit.
Okay, thank you.
Representative Lascelles.
Thanks for taking my question. So I would assume the current state of the law, it would be an assault charge. Is that correct?
Yep. And I'm not sure exactly how that gets charged, but it's usually kind of under a misdemeanor or a violation or whatever.
Follow up.
Follow up.
Do you feel that because of your uniform and because of your status, that you are more vulnerable and more of a target in the general public?
Yep. Sure am. I mean, uniforms look similar. Been called a cop and I have to go, hey, no, EMS. Have you ever had a gun pulled on me? And, I had to prove that, hey, this is a medical bag, not a gun, so please don't shoot me. Right? So, and that happens more often than you think.
Thank you.
Representative Knoll.
Thank you, Madam Chair, and thanks for taking my question. I think I first of all, I agree that if we put you in a situation where you are, going into a situation that's going to be tense and things like this might happen, we're sending you into that situation. Could you give me an example of what that looks like for someone who is not in uniform and not at that time on the clock?
Not in uniform, and if I'm not working, this law doesn't apply to me. It may apply to police officers unless I stop and render help, right? So if I'm stopping to help somebody, I don't just walk up and start touching them and doing. I identify myself. I am an EMT. I'm here to help you. Can I help you? Because I need their permission to touch them, right? Unless they're unconscious, and then implied consent comes in, and I don't need it. right? So I never touch anybody without me asking that, identifying myself first, right? And before I touch them. I'm an EMT. I can help you. Would you like me to help you? Most of the time they say yes. Right?
Yeah, I think that would be.
So if I identify myself and they know I'm an EMT, and now they choose to punch me in the face because they don't like what I'm wearing, I don't know, then yeah, this applies, right? Because they know who I am and what I'm doing for them.
Okay, so where it talks about, I'm sorry, follow up. I'm sorry.
It's okay, Representative. It's a follow up.
Trying to remind myself. Yes, follow up, please. Okay, so where it talks about acting in the line of duty or commits an act against a law enforcement officer, whether or not the officer is on duty, where the purpose was to harm the officer because of his or her present or previous employment as a law officer, that would be.
So that's a law officer, that's not an EMT. So that doesn't apply to me. That applies to police officers or a law enforcement officer or however you look.
Okay.
Because I'm sure it's in there because bad guys remember who put them in jail and may actually come looking for them. It has happened in the past. So I'm pretty sure that's why that's in there. So if the officer's walking down the street with his family going to dinner and the bad guy's walking this way and says, "Oh, I know you," and punches them, then this should be definitely in place.
Thank you.
Representative Muse.
Thank you. I'd appreciate if you could comment on a couple of things. One is, what is the necessity, first of all, to arrest somebody without a warrant? And the other is, how do you define?
Let's just do one at a time so we can make sure we get them all answered for you.
Okay. Okay.
So the necessity without a warrant should be asked to the police officers. But I know that in certain incidents, especially if they didn't witness it, they need to get a warrant. So unless this is written in the law that they take my word and see my bloody nose, and 3 other people said that guy just hit the EMT, they don't need to go get a warrant. They can arrest them right there. I believe that's how it goes. I'm sure the guys in uniform behind me can clarify that.
So would it be helpful to the to the committee if we invited Representative Mannion to sit at the same time with Representative Prue so we can get our questions answered? You guys all okay with that? Okay, Representative Mannion, if you don't mind, thank you.
So I'm going to guess that 92.5% of the time, any of these offenses are going to occur in front of a police officer. But that being said, we're allowed to make arrests without a warrant on any felony with probable cause. So that's already the law. And I can also answer quickly the question that Representative Lascelles had brought up about the current state of the law. In my career, I had a judge who told us, do not bring any assault against police officer charges. We would just charge him a simple assault or under the regular statute because he will not entertain them because that's our job to be assaulted. So that's why this is needed.
Snap.
Follow up.
Follow up, Representative Muse?
So if I understand you correctly, if the penalty was not a felony, you would not be able to make a warrantless arrest. Is that correct?
Yes.
And one more follow up.
Unless we witnessed it.
Thank you. And I'm curious about, I understand, the reason why knowingly or recklessly causing bodily injury is in a bill like this. I think we all can have a pretty good idea what that would be. What I'm struggling with a little bit is unprivileged physical contact, because the way the bill is actually written, it seems like, on the one hand, you'll get charged if you bash somebody in the nose and break their nose and they get a bloody nose and you injure somebody. On the other hand, unprivileged physical contact could be anything from inadvertently brushing against somebody, a push, it just seems. I'm just curious why it's in there at the same level as what seems like a pretty serious assault.
Yes, so that's in the second degree assault level. So the penalty is less. That's a B felony. The goal there was just to prevent assaulting police officers. I understand the concern there, where generally speaking, the general public, any kind of unprivileged physical contact, the definition would mean any kind of touching whatsoever. So it's possible we can clarify that section of it or remove it, but the goal is to prevent any assaults. So I mean, you could push an officer, punch him, and not cause bodily injury. Should that be okay? Should that be a violation or a misdemeanor? That's why we enhanced it a bit. So, thank you.
So if this helps anybody, clarifying this would also be a question. So I'm, I serve on a board for the county level for juveniles that found themselves to be arrested. And there had been a situation where somebody, it was a domestic violence situation, but it actually involved teenagers. Okay. And when the officers came, the one youth was very concerned because she felt as if she was getting in trouble when she was the one that called for help. And where the confusion was is she wasn't being in trouble, but the officers were trying to remove her from the situation, but she was very, very erratic. She was just, the situation was bad. And unfortunately for her and for the officer, she bit him. And she did draw blood. It was pretty bad. But they didn't, the charges that she had was because it continued after they stopped it. Right? Like you're biting us, right? So there was, my understanding was that was a pretty clear line of the officers actually trying to help her with the distress that she clearly had. And then there's also this line of, okay, now you're just angry and taking it out on us. So in that situation, how is that handled, or like what is the professional line where an officer is clearly able to see this person is under distress? They're not necessarily mad at me, they're just mad at the situation and I happen to be in the way. Is there a line there, or is it a matter of opinion where professionalism comes into play?
Yeah, so that's going to depend on a lot of things. The officers involved. I'm not going to speak for all of them. And it's also going to depend situation to situation. So, I mean, a situation like that, you're there initially to either arrest her, take her into custody, get her help, whatever your cause is. But there does reach a point where you can sense that she's now turning on you because you've got your hands on her. And it's not about the situation that brought you there. So that would be probably where the line is, where you give them a warning and a second warning, and they're still coming after you at that point, where you would draw that line. And in that case, if she's a juvenile, this doesn't change the juvenile laws.
Right.
So she would still be charged or not charged based on that. But so it doesn't change anything else other than the penalty for this offense. So,
Okay.
yeah, thank you.
Thank you for that explanation. I think that might be helpful to people that have some questions. Oh, who else? Anybody else? We good? Wait, Hope, what do you need?
So,
Yeah, please fill out a pink card. You can go testify. Sure.
so I'll add a little bit more because I know, like in the police world, I actually have a bald spot on the top of my head,
Thanks for sharing.
and and it came from a little old lady who was in a nursing home, trashed the whole day room, and we were trying to get her out, and she needed shoes on. So as I bent over to help her with her shoes, she grabbed on and ripped it out. The thought of charging her never even came across my mind because she was obviously in a crisis and was just going with it. So we take that into account. You know, we're not here to try and get everybody arrested that touches us. It's for the ones that do it deliberately, knowingly or whatever. So,
Yeah, so in that case, if it was a 16-year-old male football player who was 6'2" and 280 pounds, you might not give him as much leeway as you would, say, a 14-year-old 90-pound person who's flailing and stuff like that. A bite, that's different. It's no matter who it's coming from, but yeah, so it depends on all those factors.
Okay. Thank you. All right. Oh, so close, gentlemen. Representative Knoll?
One more question, I promise.
Sure.
I do a lot of work in trauma-informed care and stuff like that, and I think that a lot of the situations that we're describing, it reminds me very much of, to an extreme degree, but situations that might arise because of someone's trauma. Do you guys go through training, trauma-informed training, as police officers and EMS?
Yeah, we do quite a bit, yeah. Either from the academy or from private agencies that would come in and do training. Yes, we do.
Okay, thank you.
Thank you, gentlemen. Holly Stevens? Representative Paquette, just so you know, I generally would call any representatives first, but we've had people that obviously are trying to testify, and they might be able to clear up some of the questions that were asked. So please don't think we're ignoring you. Okay.
Madam Chair, members of the committee, my name is Holly Stevens. I'm the Director of Public Policy at NAMI New Hampshire, the National Alliance on Mental Illness. NAMI New Hampshire is a nonprofit grassroots organization whose mission is to improve the lives of all people impacted by mental illness and suicide through support, education, and advocacy. On behalf of NAMI New Hampshire, I am here today to speak in opposition to House Bill 59, but not, completely in opposition to it, just to, ask the committee to kind of look at it, slow it down, and see, how the advocates can work with the first responders to get some language that will work for everybody. NAMI New Hampshire firmly believes in and supports the critical services that first responders provide for the safety and well-being of our communities. Oftentimes, individuals in mental health crisis find themselves interacting with first responders on some of the worst days of their lives. We find that first responders are an important element of the mental health crisis response, and their safety and well-being must be crucially protected. However, we have significant concerns that House Bill 59, as introduced, will significantly and punitively impact individuals with mental health crisis, and believe that people in crisis deserve treatment and support, not to be arrested, jailed, or facing disproportionate penalties. As you've heard, under the current law, police cannot arrest a person for a misdemeanor offense unless it's committed in front of the officer or if there's certain conditions that are met. Senate Bill 59 would instead provide that warrantless arrests for any individual accused of assault of a first responder by raising it to a felony level, and that's what makes them able to arrest without the warrant, is because it raises simple assault to a felony level in this bill. As mentioned earlier, folks with mental illness often interact with first responders on the worst days of their lives, and as such, their actions may be reckless or unpredictable and may result in bodily injury or, more importantly, the unprivileged contact that you heard about. Therefore, we expect this bill would cause more individuals with a mental illness to often face the higher penalties established in the bill due to their frequent interactions with first responders. This bill would also make obtaining release on bail more difficult, resulting in more folks with active mental illness residing in jails around the state. While the committee may determine that there is a need to provide increased protections for first responders, there must also be a balance of protecting the rights and the freedoms of individuals with mental illness. And just by way of background, from 2021 to 2023, NAMI New Hampshire was involved in a stakeholder group discussing a similar issue that's the subject matter of this bill when it came to healthcare workers. As a part of that effort in 2021, there was a committee to study workplace safety in healthcare settings. During the 2 years that it met, the legislative committee worked with stakeholders, including NAMI New Hampshire, to come to a resolution that prioritized the safety of healthcare workers while also addressing the concerns of mental health and the disability advocates. This resulted in language that passed in Senate Bill 58 from 2023. And as we can learn from that process, changes in the law that may disproportionately affect the rights of an already vulnerable population should use time and careful consideration to make sure that an axe isn't being used when a scalpel could do. It is paramount that people in psychiatric crisis continue to have the due process protections afforded to them under the law. And if House Bill 59 passes as is, we expect that more people in a mental health crisis would face higher level charges and languish in county jails, which would only serve to exacerbate their crisis. For those reasons, NAMI New Hampshire is in opposition to this bill, as I said, as it is drafted. And while I was back there, I am an attorney, but I've never done criminal law. But while I was back there, I did look up the definition of recklessly, which is consciously disregarding a substantial risk of harm to others. And when someone's in a psychiatric crisis, they may know that flailing their arms around and touching somebody is, they're knowingly doing that. They're knowingly flailing their arms. And I would, as I said, I don't do criminal law, but I would be seriously, concerned about the standard that's in here. If it was purposefully, that might be different, but we're really concerned about the standard that's in here, because if someone's just flailing their arms around in a psychiatric crisis and happens to hit but not injure a first responder, they could end up with a felony on their record, which would seriously impact their ability to get employment and to get housing. And so we just urge the committee just to slow this down a little bit and allow the advocates to maybe work with the first responder community to come to a resolution that everybody can live with. Thank you.
Thank you, Ms. Stevens. Have you reached out to the sponsor of the bill to have a conversation with them about the concerns or the changes that you would like to see in there?
I didn't reach out to the sponsor. My first effort was to reach out to the person who represents the police chiefs, and was not able to connect with her in the time frame of when this bill was being heard.
And could you share maybe some of the, so you had said not to take an axe when maybe a scalpel would do. So it seems from the language in the bill that there is a scalpel now that is used. What would be some of the suggestions that you would like to see? I guess I should finish my sentence.
I'm just looking at it now. I mean, I think, like I said, the standard that's being identified in the bill is concerning to us.
Bless you.
I've got the wrong bill in front of me. Here it is. The recklessly standard is concerning.
This one's mine.
And then the unprivileged physical contact is concerning, because that is simply, touching somebody without any harm whatsoever. So those are some of the concerns. And also raising this to the felony level is concerning. It would be, I think we would rather work with the first responders within the warrantless arrest statute itself to try to come up with a carve out in the warrantless arrest statute that would allow for a warrantless arrest without it being a felony. So those are some of our concerns that we would like to, talk and try to work out if at all possible.
Thank you. Representative Scheer?
Again, in the interest of full disclosure, Ms. Stevens has the misfortune of being a former student of mine. She was a teaching assistant. So, would it be fair to say that if the words were, instead of being knowingly or recklessly, it was purposely, that would be that would address a lot of the circumstances, if not all the circumstances?
Yes. Purposely is a much higher standard to reach, and if somebody just flailing their arms around in a psychiatric crisis wouldn't necessarily it wouldn't be the standard, they wouldn't reach the level of purposefully, but again, they would potentially reach the level of recklessly. So that is the concern.
Follow up?
Follow up?
And it's fair to say that this bill also addresses another category of people that, in my experience, being a police commissioner, the police deal with in a relatively regular basis, those elderly people who are suffering from dementia or whatever the particular term is, and is not fully conscious of what's going on around them. Freudian slip. This addresses that group too, and the concern is the same, that recklessly is too low a standard.
Yes, and I know that my colleague, Ms. Karen Rosenberg, will be discussing Alzheimer's as a concern. But yes, that is one of the groups that also would be caught up in this. That we could end up with folks with dementia in the county jail, and not even knowing where they're at and what's going on, which would be a huge concern for them.
Last follow-up. Are you familiar with the kinds of services that would be available to a person suffering from a mental illness or suffering from Alzheimer's or dementia while they're being held pretrial at a jail?
It's my understanding that there aren't really any services that are offered pretrial.
Thank you.
See no further questions. Thank you.
Thank you.
Yeah. Representative Paquette.
Thank you for letting me speak. Kathleen Paquette from Manchester. And this bill is important to me and my family because I have two daughters. I was an EMS myself, and I have two daughters. One's an EMT, one's a paramedic. And my husband has been a paramedic for 38 years. And all three of them have been injured or have been hurt. So I'm hoping I have some personal experience which may help Representative Muse's question about touching, and also Representative Newell's question about being in plainclothes. As far as the touching, one of my daughters, she was actually 19 years old, and she was in the back of an ambulance with a patient, and so her driver, so she's alone, and her driver was driving them to the hospital, and the person that was driving had no idea that the passenger in the back, the patient, had my daughter by the throat. She wasn't injured, but it was intended to cause an injury. It was intended to seriously injure her. So thankfully, somebody was able to stop the ambulance, get out of the ambulance, and intervene before she got an injury. So I think that's why that touching is very important, because she wasn't hurt, thank God, but that physical touching was intended to injure her. And as far as the out of uniform, like I said, my husband has worked for 38 years in EMS, and he does not work in the state intentionally because he's had episodes in the past where he's had patients that he's ran into in the grocery store. And not everybody, loves EMS because either they don't take them where they want, or, like Representative Prue said, you're ruining their high as they see, but you've just saved their lives, and they're not happy. So he's actually had several incidences with people recognizing him out of uniform. So he, therefore, for safety, his own safety, he chooses to work out of state, so he's not recognized. Thank you. And thank you for taking my question. I know, one thing that I'm very familiar with is I just want to talk about kind of this idea of like ruining somebody's high, right? And kind of drill down on what that looks like, because I do know that when people are resuscitated with naloxone sometimes, when they wake up from that, essentially, when they come back, they are flailing. They don't know what's happening. They're very, very disoriented. And so I just want to kind of establish exactly what that looks like? Because I can imagine that being possibly misinterpreted by some.
It can be, but there's sort of a little bit of a timeline because that's something that I had experienced myself. And, somebody comes out and they're flailing and they're mad, but usually several moments later, they realize that, they're now sober. And it's usually upon that they, at times, not everyone, obviously not every single time and not everyone, but that is the time when they realized, oh, I was high and now I'm not, and it's your fault. So, that initial sort of waking up, there can be flailing in that, but then there's that moment of realization that comes a little bit after.
Okay.
And that's only from something that I had experienced. Thank you.
Guess I should turn it.
Thank you, Madam Chair and members of the committee. My name is Kate Horgan. I'm here representing the New Hampshire Association of Counties, which is the trade association for all your elected and appointed officials. The association is in support of this bill, but we would like to make one minor suggestion that you add correctional officers to this list. While correctional officers are considered law enforcement officers, in the past, if they have not been specifically listed, they are not included. Certainly, the second half of the bill, counties are certainly set up under the magistrate program to handle the bail via judge or magistrate, so that would not be an issue for counties. Certainly, we do not want people languishing in the county correctional facility who are in mental health crisis, but we feel that there are procedures in place to handle that bail situation if someone were to come in. And as far as the felony, that is a policy decision. It is not a position that the association is taking at this time. But I'm happy to answer any questions that you may have.
Representative Knoll,
Yeah, I didn't talk at all yesterday, so I'm
you
just
did.
picking up for
You're doing a great job. No reason to apologize.
it. Excuse me. Thank you for taking my question. What Representative Scher said about pretrial services really kind of struck a chord with me, and I was wondering if you might be able to speak to what exactly that would look like and being able to identify whether it was someone who was in a mental health crisis, in which case we wouldn't want them to be held in that situation.
Sure. Thank you for that question. That's not a decision for county corrections. That would be a decision for the judge or the magistrate who is seeing them.
Can I follow up real quick? Because my intention is not to say it's what I'm really trying to ask is kind of what that looks like if someone does, and that's not something that you feel comfortable speaking to.
Thank you for the question. I believe I can answer your question. If I don't get it right, try again. So if someone comes in, last year, this committee did extraordinary work around House Bill 318 and set up the 13 crimes that are listed that include first-degree assault and second-degree assault for someone who would not see a bail commissioner. They would see either a judge or a magistrate. We've worked very closely with the courts to set up those procedures. So if you come in during the week, normal hours, within 24 hours, you have to see a judge. If you're coming in on the weekends, you have to see the magistrate because obviously the judges are not in their office. And we have worked out essentially a schedule with the courts for every county to have a specific time where if they have someone who falls under those jurisdictions to set up a call so that they can have their review done within the time period that you all laid out in 318 last year. Counties have set up virtual hearings so that way we don't have to physically bring people to the courts. We can do it over Zoom or some other telephonic communications. Does that answer your question?
Yeah, it does. Thank you.
Okay.
Appreciate it.
Anybody else? We all set?
Thank you very much.
So, Representative Prue, I realize you were telling me you could answer that question, but if you could maybe after we're all done, just like address that so we can let the people testify. Thank you. Karen Rosenberg.
Good morning. My name is Karen Rosenberg. I am the policy director at the Disability Rights Center, which is our state's protection and advocacy system for people with disabilities. And I'm here to testify in opposition to this bill on behalf of the Disability Rights Center. I mean, first, I need to say that someone said not everyone loves EMS providers. I love them. I understand their jobs are so tough and that they go into situations intending to help people, save people's lives, and are entering sometimes situations that end up being harmful to them, and that is terrible. So in no way, I mean, I can't imagine what that's like for them. But what I'm concerned about is that this bill, if it passes as written, is going to have an unintentional, really negative, horrible consequence on people who experience various kinds of disabilities. As you heard from Holly Stevens from NAMI, there's concerns about people who are facing an emotional, behavioral, mental health crisis and are just hearing voices or having a break really with reality and are very, very agitated. But I'm also concerned about people who are experiencing intellectual or developmental disabilities, people with acquired brain injuries, people like my dad who suffered from Alzheimer's. And this is very emotional for me because my father, who was the sweetest person, I mean, I'm older, right? My friends, they did something wrong. They get a little whack. I got a lecture, okay? He never raised a hand. But when he was in his 80s and his mind was getting erased by this terrible disease, he became aggressive and sometimes agitated and sometimes even violent. He wandered a lot. And even though he was older, he managed to elude my mother and sometimes would just disappear when she was trying to do something like, run into the library to, give her, return a book or whatever. And that would be it. He also had physical health issues. He had heart disease. And so I can just totally envision the time where, there were times when she would call the police or someone for help. And if someone approached my dad, even when he was in a care facility, when he didn't expect them, and they were trying to help him, it might be with something that had to do with taking care of, like wiping off his face, if there was something on it, anything, he would reach out, grab them. He bruised my mom, who tried to help him to take some medications at one point. But this was his disease, right? This isn't something that you'd want to see him hauled into court or to jail about. And and the idea that, oh, sure, he'll get before a magistrate or a judge within 24 to 36 hours the harm that would be done for him being out of his environment and for what purpose? When I think about what is the purpose, there are various purposes of our criminal law, right? One is to punish people who do objectively bad things, right? They cause physical harm. They do something, breaks our civil code. It's also a deterrent, right? I don't think that this kind of legislation is going to prevent these kinds of unintentional acts from happening. And sometimes there could be harm involved. So what this does is it takes a misdemeanor, which includes unprivileged physical contact without harm, but also it could include the kind of injury that my father caused when he would, try to get someone away from him and cause a bruise. That would be bodily injury. And it raises that to a felony. It means that someone in that position, and right now, if that happened right now, today, that would be a misdemeanor. Someone could go and get an arrest warrant and have my dad arrested. But in the meantime, he would be transported to wherever it is he needs to get his care. And he'd get his care. And then if an arrest warrant issued, then that happened and he'd have to deal with it. It's not like there's no consequences possible. But then all these issues around competency could be raised. I'm using my dad as an example, but you can see it happening with someone with a developmental disability, a brain injury, someone who doesn't have the executive functioning skills intact to know what's going on. Now, I have to say, it was heartwarming to hear Representative Prue's testimony about the unfortunate loss of a hair, which is terrible. And I'm sure that really hurt a lot. And it was really heartwarming to hear that that he was kind and understood where this was coming from and made a decision that this was not something to be prosecuted. But we would have this on our books, and not everyone, not every person who's a first responder, even though I said I love first responders, but I don't know that 100% of them are as caring and would take that kind of rational, just humane approach to a situation that results in some pain and an injury, like loss of hair or something else. So for those reasons, I think this is really problematic, overly broad. I think it's not going to prevent injuries to our first responders. There may be other ways to prevent injuries to first responders. I don't know exactly what some of them are. I think that it's just, it is a problem that we ought to study and try to make more resources available to those folks, because they are trying to, they are like our angels, right? But I feel that the consequences of this are really dire. So for all those reasons, we would oppose the legislation, this bill as drafted, and I'm happy to take any questions.
Representative Murphy?
Thank you, Madam Chair. I empathize with your situation. I too had a parent with Alzheimer's who behaved much the way you do. And I also have a son with a traumatic brain injury who has minimal executive functioning skills, both of which would concern me in this issue. As a healthcare provider, a former nurse, I too recognize that we need to be able to protect those people who are trying to help our patients. I'm not sure, but I believe that I was on the subcommittee for that prior bill about health, which addressed pretty much the same situation, but with a different population. So we were healthcare providers.
SB 58, and there was a workforce, healthcare workforce coalition that DRC played a role in also.
That was what was my question was, were you part of that? And did you have suggestions as to how we might make this better so that we achieve the protection that we need for EMS, but also protect the vulnerable populations that they may be, that they are facing every day?
Right. So my predecessor, I've been in this role. This is my fourth legislative session. My predecessor, Mike Skibby, who was our policy director before me, was involved in that directly. And then I was involved more recently in sort of honing the language that resulted in SB 58, which ultimately passed. So I would welcome the opportunity to work with folks on trying to address this issue. It did take some time, as I understand it. One of the things that the Healthcare Workforce Safety Commission did was they also looked to collect data on this, and I think that would be really important to understand how often this happens, who are the folks assaulting our first responders, and what training is there, what are the factors leading up to this. I think there's information that would be really helpful to gain if there was some further study done, in addition to looking at what you're talking about, Representative Murray, and how it is that we could carve out situations where we're not, punishing people whose behavior is really directly related to having a disability, but not allowing folks who, who have that mens rea, who have that purposeful intent, and to harm someone who's there to help them. That might be something to really work on, but I don't know that. That's not an answer that I can just quickly come up with. There are also already, there's in our criminal code, as I understand it, there is a specific provision that protects corrections officers from assaults against, well, it doesn't protect them. It creates an additional felony when prisoners assault and harm a corrections officer. So that does exist already. I think I pulled it out. It's it's RSA 642:9. So, and if someone is a prisoner and they commit an assault as defined under 631, which is the RSA you're looking at amending now, it would be considered a Class B felony, and then the sentence would run consecutively, sorry, with the sentence that the person's already serving. So there are protections there. And I couldn't help myself, but Representative Lascelles, there is a statute already that adds it to be that creates a crime, it may also be a felony. Hold on, for assaults against someone who's like in the general court or or elected official. Yeah, I'm gonna find it for you because I did. Oh, here it is. 631:4-A, harm or threats to certain government officials. So that does create an additional Class A felony.
Representative Scheer.
Thank you, Madam Chair. What language would you recommend to sort this out?
I like I said, I don't think I can come up with that off the top of my head. I'd really want to think about it. I think it's complicated because one thing I worry about is how is someone who is like an EMS gonna know that the person they are being flailed at by has one of these conditions? So I don't know the answer right now. I think if we can think about, I think put some brains together, we can come up with something.
Well, let me,
Follow up. I do believe that they are very much trained on that. As a matter of fact, certainly to recognize those, and if they're with a family member, that would certainly be a tell when they're letting you know that. But follow up.
yeah, and in that vein, Madam Chair, I'm aware, the Portsmouth Police Department gets a lot of training. The officers get a lot of training on managing those who are in mental health crisis. And we avail ourselves of the mobile crisis units. But what about language that carves out of this statute a certain population? Do you think that's a good way to approach this, or I'm just getting your general thoughts?
I mean, it might be. I'm also thinking about like people who are deaf and hard of hearing who might respond in a way that's unexpected. I mean, there may be other kinds of disabilities. Perhaps I don't want to say no. I think I'd like to work on it. There may be a way to do this, but I think it would require some thought. And I am aware that there's a lot of training for police officers through the police academy. I don't know how much training there is available for EMS workers or EMTs, if it's as robust, and if there's, what the breadth of and depth of training is in terms of trauma-informed approaches and de-escalation and those, which is really important when you're approaching someone as well. So that would be something to consider.
Les.
Fortunately, we have several firemen, EMT, and police officers on this committee that could tell us that whenever we go into our executive session. Just so everybody knows, we are coming up to pretty much an hour. We still have 3 more people that would like to testify. So if we could make sure we just really kind of answer the questions at hand. Representative Muse, did you have a question? I thought I saw your hand up. You're all set? Okay. All right. Representative Newman?
Thank you, Madam Chair, and thank you for taking my question. I have a concern about on the last page of the bill, on page 1, it talks about the extended term of imprisonment under 651(6)(g)(1) to read as follows. And then I don't see, I'm having to, I'm sorry, that was a different issue. Can I correct my question?
Yes.
I'll get to that. I'll figure that other one out later on. There is a term on the page 1, line 14, that talks about 597. A defendant is dangerous under RSA, and it references paragraph 3A1, and I don't know if you have anything in your information when you studied it, and for the sponsors, it's just that I can't find it anywhere, and I've searched all over the computer to just find the citation that's there. So we may need help with that later. Thank you, Madam Chair.
So I have never practiced criminal law.
Okay.
I did look at this RSA, and so I will tell you what my quick understanding is, but I suggest that you speak with someone, ask this question of someone who has. As I understand it, what this would do is create a presumption of dangerousness, which is a factor that a court would look into in terms of determining whether to allow the person to be discharged on personal recognizance or bail, as opposed to having to wait at the county corrections facility before they have their hearing. But like I said, qualify that.
Thank you very much.
Thank you. Okay. Right. Thank you very much.
Thank you.
Lauren Barry.
Hello, everyone. My name is Lauren Berry. I'm a certified firefighter, advanced EMT in the state of New Hampshire. Bear with me, I'm really nervous because I am not a public speaker. To give you a little background on myself, I have practiced medicine since I was 18 years old. I'm now 35. I've practiced in places in the state of New Hampshire, more so in Epping, New Hampshire, and Manchester, New Hampshire, both different demographics. I now currently work in Somerville, Mass., Everett, Chelsea, all very different demographics. I've worked in New York with FDNY and Harlem, Queens. I've worked on the border of Mexico in very poverty-driven places, La Jolla, Brownsville, New Jersey, Newark, Jersey City. So to say that I have a diverse background in different demographics and the different types of patients you can encounter on a 911 call would be an understatement. Me personally, I've been assaulted and verbally, physically more times than I can count in this career, as well as my coworkers. I personally, 2 years ago, was assaulted to the point where I required an ER evaluation after the call. I was kicked in the face and the chest multiple times from a patient that made an active decision to drink that evening, and through that drinking was angry that that particular patient had to go to the hospital. And while taking that patient out of the ambulance, I was in a vulnerable position doing my job. In front of an officer, I was kicked in the face and the chest. It was on camera. That patient faced a misdemeanor charge and was let off with rehabilitation of rehab. That should say something. That people that advocate for mental health patients, I'm now a mental health patient. Where's my advocacy? What point does my life matter for somebody to protect me? Everyone, I invite you to come work with us for a shift. I invite you to come see the discretion that we have with every individual patient that struggles. I invite you to come see how much training we have to decipher whether the patient has a mental health crisis, whether they have a brain injury, whether they have dementia. There's a lot of signs. There's an abundance of training that we go through. We are given a role in this uniform that we are allowed to make decisions. We are licensed to a level of standing protocols that we're allowed because we're trusted with these decisions. We're trusted to save your loved ones' lives with medication and decisions critically thinking in chaos. So to think that we don't deal with discretion and take the time to have an understanding of if the patient's having a mental health crisis versus intently making a decision with intent to injure is slightly, no offense, disrespectful. I take this job so seriously, most would say I put it before myself more days than not. In fact, I should be at work right now. I'm missing pay to be here because that's how important this is to me. When I found out that this state didn't have a felony charge for somebody that kicked me in the face and the chest and not get penalized for it, choice words were made, let's just say that. I think, I can't speak for the sponsors of this bill, but I think the point is being missed here, that we're not just going to charge every single person that raises a hand to us. This bill was meant and created with a purpose to have protection and to uphold a standard that will not be tolerated, that we will be assaulted because someone got angry. When you were taught as a child that you had big emotions, were you penalized and punished for hitting your classmates, your siblings? Why is it okay to hit somebody in uniform that's called to help you? I didn't sign on for a job that, the years I've been doing this, I can't tell you how many new hires and probies. Oh, violence is just part of the job. Why is that an acceptable thing? Why am I okay with accepting that? You wouldn't accept it in your relationships. Why is it okay for me to accept it in a uniform? Because someone called 911 and I responded. The amount of times I've been assaulted and never once sought to seek charges on that person, whether it was because someone told me they wouldn't go anywhere, the person wouldn't show up for court, that it was a waste of time. When this happened, the prosecutor called me and said, yeah, nothing's really going to happen. She's going to go to rehab. She admitted that she has a problem with drinking. Okay, so in the future, when I get in trouble, I can just say I have a problem with drinking. That gets me out of the decisions that I made during that time. the amount of training that we go through, the amount of extra effort we go to on each call, the amount of tact that we have with each patient, the amount of times that I have called someone sir after they've called me a derogatory name. Please understand that we love your loved ones. We wouldn't if we didn't do this job because we don't get paid. I can't tell you how many people in uniform have multiple jobs because we don't make a wage that really supports cost of living in these days. And that's a whole different issue. But I'm just saying, most people that wear this uniform, it's because they have a passion for it. They have a passion for taking the extra. Last night I stayed 25 minutes past my shift because an elderly woman with dementia who is anxious couldn't find her glasses, and she was vicious. Gosh, was she vicious. Her issue was she couldn't find her blue eyeglasses, and I wouldn't leave until I found the blue eyeglasses. Was that my job? No. But did it settle her for the night? Yes. I'm just trying to say, I had this whole thing written out. I was going to be so tactful and professional, and
You
I
were great.
realized I'm just going to be myself. I've been shot at in this career. I have been held captive in apartments. I have been spit at, kicked, punched. More times, you know, the person that's having the mental health crisis, you take the extra time to still talk calmly to them. The person with the disability, you take the time to talk quietly, to take time with them, to get down low on their level. The person with an elderly issue that's digging their nails into your arm, you ask nicely, ma'am, can you please release my arm? You don't dig your nails back into her arm because she's hurting you. Did I swing back on the person that hit me? No, because I'm a professional. This bill wasn't put in place so that we can just carelessly throw felonies at people that raise their arms or their feet. It's with a purpose and with intent. You make a decision every single day of your life. If you chose to get up today and go drink, from that drinking and what occurs in that drinking was your choice. If you chose to get up and to do drugs, that's your choice. I understand people with mental health issues. I have my own now from this job. I understand people that have traumatic brain injuries. I have the utmost respect for them. That must be really difficult to live like that every day. People with dementia, it can happen at a really young age. You could be 45 years old with early dementia. You can't just assume because they're young that they don't have dementia. I ask you to be a little more informed in what we do with the uniform, and please, at any point in time, if any of you would like to come do the job with us for a few hours, feel free. I would gladly take you around. This bill was just meant to protect us in the situations like mine where I took a boot, a work boot to the face and the chest, and nobody was held accountable for it.
Thank you, Miss Berry. Just one quick question. Where were the blue glasses?
Under the computer.
Naturally. Thank you very much for your testimony.
You're welcome.
Amanda Azad.
The seating options up here.
ACAD, right?
Chair, committee members, thank you for your time. I appreciate that this hearing has run over time, so I will try to fly through this. And if you all have questions, I appreciate that, but I also respect that you all have more hearings. So I believe there are, of course, very good intentions behind supporting the concept of this bill, but I urge that you pause and not move forward at this time. I ask the committee to pump the brakes on going down the path of adding further enhanced penalties based on career or profession, especially when we already have extended terms of imprisonment in our laws when a victim is an emergency responder. If those aren't being used, that's a different conversation. We need to acknowledge that if a statute is not working, creating additional statute language is not really solving the things that are being testified to today. The opportunity to coerce people with the threat of very long life-destroying sentences creates an off-putting power dynamic that can lead to abuse. I think that's really important when we've seen these bills in other states. It's important to highlight again, New Hampshire already carves out enhanced penalties for the exact emergency responders listed in HB 59, but in a different way. If you want a special place in our laws for emergency responders, we have that. We do acknowledge and value that they go into very dangerous places and deal with very intense situations on a routine basis. However, going much further than what we already have in statute and adding specific careers directly into the assault statute itself is all deeply concerning. HB 59 is changing a lot about our criminal law statutes, changing the level of offenses, changing the person's rights pre-trial, changing the years of incarceration, and changing the standard and harm required for these new felonies. For example, second-degree assault, a felony facing up to 7 years in prison, would be changed to just any bodily injury. That would include a scratch. While the folks who testified today, I understand, would not potentially seek charges there, the criminal legal system is very complex, and individual situations get very heightened very quickly. And we do not need these really overwhelming types of charges lingering over people's heads. It even has only unprivileged physical contact. That's no injury required for a felony assault where you could get up to 7 years. Something I'll discuss later is the importance of, when it comes to plea bargaining, what actually happens when you're facing these types of really intense prison sentences. Folks are not going to trial. That rarely happens except for in Law and Order. We're talking about negotiations and the power dynamics that come into play. Currently in New Hampshire, if someone knowingly, recklessly, or purposely assaults a police officer or other emergency responders, it is already a felony that with enhanced penalties may receive 10 to 30 years in prison. If someone commits simple assault, a misdemeanor, against a police officer, it may be enhanced to 2 to 5 years in prison. These are severe prison sentences. Even without enhancements, I want to flag that our assault statutes are severe in and of itself for any person. Something that I think should really be considered more than maybe some of my other points is that this is not a deterrent. And I believe that a lot of times when we are passing criminal laws, we aspire for them to be deterrents. And that in this case, especially does not work. People who are responding to emergency situations are often dealing with, as discussed here, people who are in their worst moments, their worst marital moment, possibly having a mental health crisis under the influence, dealing with medical issues, conditions, disabilities, PTSD. There's a heightened stress, anxiety, and panic. In this situation, despite best efforts, no one is going to remember if they ever knew the difference in prison lengths under HB 59. They may not even understand fully what's happening, where they are. They're panicking, maybe not even thinking what they're doing is assault. Deterrent is not happening in this specific case. Someone who's willing to knowingly and truly assault an officer or an EMT is not going to stop and calmly think through the sentencing guidelines associated with that either. We do not want everyone in these heightened states or under these circumstances criminalized to such a severe degree. We need to fully consider, will this be a tool to force plea bargaining or other problematic outcomes with many vulnerable defendants? We are talking about automatic felonies for a host of wildly different types of community members with different reasons for their actions. We are also talking about a situation where police or EMT are now walking away with potentially no injuries or a minor scratch, and the other person is now facing years in prison, and the dynamic that then creates. I asked the committee to take time to discuss whether this will be a deterrent or if it may be more along the lines of seeking increased retribution with very long and expensive prison sentences. Though I very much appreciate the good intentions here, we have real concerns of police overusing the charge, especially in cases where they fear the person will claim police brutality. We have seen this in other states with similar laws. Assaulting police and emergency responders is, of course, never okay. No one here disagrees with that, but that does not mean that we need to push incredibly long prison sentences where the laws are already in place for both the police and prosecutors to handle if someone assaults one of their own. If they're not handling that, that's a different conversation. Felonization in this manner increases the chances that people will be forced into plea bargaining, with the threat of felony charges. Also, lastly, I would just like to add who gets added next to our assault statutes. As we have seen in many other states, once a criminal statutes are expanded to include specific occupations or professions, the push will continue to add more professions. I've seen bills for bouncers. There's a host. This is a large thing I think we should pause and discuss. I don't think we want to go down this path of ranking different professionals to a higher class directly in our criminal laws. In some, there's good reason to reconsider HB 59. Mass incarceration has been and continues to be fueled by ever increasing long sentences. Longer sentences have not been shown to be a significant deterrent, and people incarcerated will only consider to get older and older in our prison system with long sentences. If the goal is to support emergency responders, let's use tax resources that would be wasted on further prison sentences on increasing emergency response times, more robust rural ambulance services, and other much needed supports in our community. Thank you for your time. I know it's been a long hearing.
Thank you. Yeah, Representative Murray.
Thank you, Madam Chair, and thank you for taking my question. I wasn't sure if you said the RSA where the extended prison term already exists. Do you have that on hand?
I do. I don't have all my notes, but I believe it's RSA 651:6.
Thank you.
Thank you very much.
Thank you.
Beth Sargent.
Good morning, Madam Chair, members of the committee. My name is Elizabeth Sargent. I work for She Infinity Capital Group here in Concord, and I'm here today representing the New Hampshire Association of Chiefs of Police. I'm just going to make a couple of statements. I know it's been a long hearing. We are in support of this bill, and I just want to say knowingly or recklessly causes serious bodily injury. We think this is a serious bill, and I will apologize to Holly. She did reach out to me. Absolutely. We are monitoring every bill in your committee. So every night, the night before, we're working through the next day. So we are more than happy to sit down with the stakeholders in this room. I've spoken to the sponsor. We're happy to work in a subcommittee to flesh out some of the issues that were raised. And the only other thing I did want to say, we did look at Senate Bill 78. We think that is a specific healthcare setting. So we think that is not the same as this bill. And I guess I just wanted to say, in representing law enforcement these last few years, I think they do take the totality of the circumstances into consideration. And I think they're very much aware of the public that they are protecting. And I think that they try to do their very best. And I may not be able to answer any technical questions, but I'd be happy to send those questions back to my client.
I'm not sure why she pointed at me.
Thank you. Thank you very much, Ms. Sargent. I don't
Yep.
see any questions. I would just like to point out that there was a lot of conversation, amendments, change this, change that. If the sponsors are interested in doing that, I would encourage you to reach out to the people that showed interest in wanting to do that, just because of the large number of bills that the committee has. That would probably be the best way to make that happen. So thank you very
Thank you
much.
so much.
I don't see any questions? Okay. Nobody else? Is there anybody else wishing to testify on House Bill 59 that has not turned in a pink card? Seeing none, I will close the public hearing. I hate to go right into the next hearing, guys, but we are about 20 minutes. So we're going to go ahead and do that. If you just need to excuse yourself, I think that would be the best way to go about that. I will open the public hearing for House Bill 109 and invite the prime sponsor to introduce his bill.
Thank you again, Madam Chair, members of Criminal Justice and Public Safety. Representative Dennis Mannion, Rockingham 25. I represent Salem. Hopefully this bill is a little easier. This is the second part of the bill that Chairman Roy filed last year. Like I said, I separated them into two bills. So what this bill does is add to the false reports to law enforcement officers statute 2 sections. One that would make it a misdemeanor if somebody knowingly reports to a law enforcement officer or agency that an officer has engaged in misconduct, if they know that's false. So it's knowingly representing a false statement of misconduct. And the second part is increases it to an A misdemeanor if they knowingly report to an agency by word or action false or baseless information regarding allegations of criminal conduct. So last year, this bill had Class A misdemeanors for both. I didn't think that was appropriate for the misconduct part of it, but only for the criminal part of it. And I'll explain. I think it seems pretty obvious, but I'll explain. If you arrest someone and they want to retaliate against you, so they come to the station and say, he was rude to me, he called me racial slurs, he swore at me, he violated this policy, that's misconduct. The penalty for that could be some up to termination from his job, but it's not going to be anything where he's going to be charged criminally. So that's why I changed it, the criminal part of it, to Class A misdemeanor. So this has to be knowingly. It's pretty high standard. If your intention is to go to the station or report that this officer did something he clearly did not do, solely for the purpose of retribution against this officer, or if you want to accuse him of committing type of a crime, and you know that it's false, but you're doing it for some type of retribution, then the second part of this would be affected by it. So those are the 2 sections of the proposed legislation, and I can take any questions if you have them.
Representative Newman?
Thank you, Madam Chair. Could you just, this is more of a process question. If this were to become law and Roman number 3 happens, what is the process? Somebody comes in and does this, then what would happen? How would this be? What would you do if that happened to you and it involved that paragraph?
So if somebody came in and made a false allegation that you committed a crime, and we're assuming at this point it's on duty, I've arrested somebody and they've claimed that I've committed a crime. More likely than not, will be on body camera. There's a lot of cameras around today, but let's say it wasn't. That would be investigated by Internal Affairs. If they don't have Internal Affairs, they have a detective or a sergeant that would investigate it, or possibly another agency that would investigate it. And if during that investigation they found out that this didn't occur and that they can prove that the person just falsely made these claims, at that point an investigation would be done against the other person for making these false claims under this statute if this would have passed. But the first part of it would be investigating the allegation first.
Follow up?
Follow up. So I'm going to withdraw my question. Thank you.
You good?
I'm good.
Okay. Representative Muse?
In this state, we have an unfortunate problem we read about almost every week. There are police officers who are charged with misconduct. We have a Laurie list that actually lists a bunch of them. So it does happen. I guess my concern with this bill is, I guess I'll just ask you. I mean, do you think that having a bill like this would actually discourage people who've experienced real misconduct from reporting that misconduct?
I don't think so. Like I said, knowingly is a high standard to reach. And certainly someone's not going to be charged and convicted of knowingly just because we couldn't prove the opposite. So let's say that he made a claim against somebody and we couldn't prove the claim true. Doesn't mean they filed it intentionally or knowingly and it was a baseless claim. I mean, we have charges or allegations that are unfounded. That's not going to trigger an automatic charge. So we would have to prove that the person did it. It was baseless information. It was false, and they knew that when they made the allegation. That's a high standard.
Thank you.
Thank you.
Representative Shear?
You said something that kind of troubles me. if somebody came into the station and said, Officer Schur was rude to me, and we're about to get body cams in Portsmouth, so they could go look at the body cam and see whether that was true before they started a IA investigation, internal affairs. I'm really troubled by the fact that the police department can then turn around and charge someone with a misdemeanor just for saying he was rude when, you know, the definition of what counts as rude really is broad. So I'm worried about the scope of how you describe what kind of reports this covered.
So in the case of somebody claiming that the officer was rude, that's all based on that person's opinion. So if they're knowingly coming in and saying the person was rude to me and they found out that, well, we don't think it rises to that level as far as us taking action against the officer, discipline and whatnot, that's not going to trigger, well, you said he was rude and we don't think he was, so you're going to get charged. That's subjective. I mean, rudeness. So I guess it would more apply to, I mean, he used a racial slur. I mean, rude is kind of a, like I said, that's subjective. I don't think it's ever going to come up. That's not what this is for. So misconduct would I mean, it's pretty clear. Anything other than that would be covered. I mean, rudeness is something that our opinion of rude is our opinion of rude. Doesn't mean you filed it incorrectly and that you're going to get charged with it, because your opinion of rude is that, and that, you know, that officer, if they determine he wasn't rude, doesn't mean it's going to trigger this. So I understand what you're saying, but I don't think it's enough to trigger a charge under this statute.
Representative Muse?
So I know the way that a lot of times police get leads in cases from people who, you know, who might call in anonymously, and with phone number tracking systems and things like that, that's a little bit harder to do these days. But in a case where somebody's calling in and reporting some type of misconduct, and the department isn't actually able to verify that, or just dismisses it outright. Are you concerned that people won't be reaching out to you in cases like that who really should be?
No, not at all. Again, it's the same answer I gave you last time with knowingly is a high burden. Anonymous reports are anonymous, and if we can't identify the person, then there's really no issue with it. This is geared towards somebody who is intentionally, their purpose is to make a false claim or false allegation against a law enforcement officer in retaliation, and that's their purpose. And it's not someone who's making a claim that turns out to be unfounded or not true. That's a different scenario. The burden here is quite high.
Thank you.
I don't see any more questions. Thank you, Representative.
Thank you.
Is there anybody here wishing to testify on House Bill 109 that has not turned in a pink card? If you could just make sure you give us the pink card for the clerk's record.
Good morning, ladies and gentlemen. Thank you very much for hearing me for a moment. I'll be what I hope will be mercifully brief. My name is Brendan Davey. I'm a major with the New Hampshire State Police. I'm the commander of our Operations Bureau, and I've been a certified law enforcement officer for approaching 24 years now. I can say, having been a sergeant and a supervisor of shifts, and then lieutenant as a unit commander and a field area captain prior to my current role, that at the same time that we do and we should take very seriously every allegation of misconduct leveled against any sworn peace officer in the state of New Hampshire, that it is and can be a reasonable concern that some of those allegations are significant and at the same time materially false. I would only submit for the sake of the sponsor of the bill and for your consideration as well, that misconduct within the state of New Hampshire in terms of law enforcement is specifically codified in RSA 10519. And that statute specifically cites, I want to say 6 or 7 particular offenses with specificity that count as misconduct. And perhaps if this statute were to point specifically to that one and say, it's not a matter of rudeness. It's not a matter of I felt that he was heavy-handed, or she, I didn't like the way that she handled me on this car stop, which are matters of professionalism and should still be investigated and should still be dealt with because we do need to be professional. Whereas what we're talking about is a violation of a law, that would certainly help to clarify things and take a lot of that subjectivity out of it. So that's all I have for you. I appreciate your time.
Thank you very much, Major. Representative Shear.
I don't know if you're familiar with the statute, unsworn falsification statute.
Yes, sir.
How does this overlap with that?
In that many of the allegations that are leveled in the cases that would, I think, fall into consideration were this statute to be enacted, the statements are not sworn at the time that they're given. And so unsworn falsification wouldn't be invoked necessarily.
Follow up?
Follow up, I'm sorry. Maybe I'm confused. The statute I'm referring to, I don't have the number in front of me, but there's a statute that says put unsworn falsification, that is, the statement isn't sworn to when it's given, but it's a falsification. There's already a statute that deals with that. My concern is that this overlaps that substantially, and I'm not sure what the need for this is in given the unsworn falsification statute.
Yes, sir. Fair question, and I'd actually leave that to the sponsor or other parties. Yes, sir.
That would probably be something we would be able to discuss at the executive session if we wanted to.
It
not
could
do
also be
away with
noted
it,
that
but-
some allegations are so significant as to constitute allegations of criminal conduct on the part of law enforcement, and there's a statute that covers that as well. False reports to law enforcement.
Thank you very much.
Thank you.
All right. Is there anybody else here wishing to testify on House Bill 109 that has not turned in their pink card? All right, seeing none, we will close the public hearing. Just so everybody is aware, if anybody's watching at home, House Bill 146 that we have scheduled for 12 o'clock. If there is anybody here today that wishes to testify on that, we are going to, of course, let them give their testimony because it is scheduled for today, but we are going to give a professional courtesy to that sponsor, and we are going to basically have a continuance of that hearing Friday the 7th, and it's actually going to be at 9:30 in the morning, a little bit earlier than we usually do things. So basically we'll, if there is somebody here, we'll let them testify, but we're going to recess and just do a continuance next week. So that's correct, because the sponsor has asked us to do that for them, and we've agreed to do that. So just so everybody knows for planning purposes today.
Just to be very brief, just for information for the committee, the unsworn falsification statute is RSA 641(3).
Thank you. All right, we will be in recess until 12 o'clock, and we'll take it from there to see who all shows up for that.
Six.
Good afternoon. Welcome back. We are opening the public hearing for House Bill 146. Just for those of you that were not here earlier, did not hear the earlier announcement, the sponsor of this bill did ask if we could please recess and reschedule this hearing. Those of you that are here, we are certainly going to let you testify and speak on behalf of the bill. But just so everybody knows, we are going to recess and do a continuance at 9:30 next Friday, which I believe is the 7th, Madam Clerk. The 7th at 9:30. You're all set, Representative Prue.
Good morning, Madam Chair and the committee. I am here to just introduce Bill 146 as the prime sponsor is unable to make it. As I understand it, it is a bill designed to keep video evidence longer for violations, where it is not kept very long for just a violation. That's all I know, and no, I am not taking questions.
Thank you, Representative Prue. Who do we got? Representative Mannion?
Thank you, Madam Chair, members of the committee, Representative Dennis Mannion, Rock 25, Salem. I oppose this bill for the simple reason that this is already being done. So violations where there are charges clearly being made are already kept for a minimum of 3 years. Anything that has a court case pending, we're required to keep these body cameras for a minimum of 3 years. What we do is, in the system, I work with Axon and I've worked with WatchGuard in the past. We set up retention rules in advance. So for an arrest, we would have minimum of 3 years. For a call for service, we're allowed no sooner than 30 days, no later than 180 days. We usually set those for 180. So there's certain time frames that we have preset in the system. So anytime there's an arrest or a charge, it's automatically preserved for 3 years at a minimum. So the retention rule, we have a separate one for traffic warnings and traffic citations. So if you're issued a traffic citation in New Hampshire, technically that's no different than an arrest. You can be arrested for a violation in New Hampshire, but in lieu of that, they issue what's called a padded summons, and you have an option of pleading by mail or requesting a court date. So in either event, though, once that video comes in, that is tagged as arrest, and that's saved for a minimum of 3 years. So there's really no need for this. The other part of this is the request of the camera recording within 5 days. This should be handled as discovery request and taken care of through that process. We shouldn't be setting a different day for 901A requests, a different day for body camera requests for violations, and then a different day for discovery. This is strictly evidentiary for the person to use in court. It should go through this discovery process. And the last part of it really raises my eyebrows. A violation being dismissed if that's not received within 5 days sounds a little bit like somebody may have had a run-in and looking to get their charges dropped. So I don't understand the purpose of that. But for those reasons, I oppose this bill.
Thank you, Representative. I don't see any questions. Looks like you got off scot-free. Look at that. Run. Quick. Attorney Enders? And injuries.
Good afternoon. My name is Stephen Enders. I'm an assistant county attorney at the Merrimack County Attorney's Office. I've been a prosecutor for over 20 years. I also oppose House Bill 146. I certainly understand that RSA 105D2, which is the body worn camera statute, has a couple of shortcomings and some ambiguity in it, especially when it comes to providing discovery in criminal cases. Those issues are hopefully being addressed by another Senate bill. There was a bill last year that went to a study committee at the Law Enforcement Accreditation Commission at Police Standards and Training, who wrote a report making some recommendations. As a result of those recommendations, there's a Senate bill pending that would look at all cases, not just violation level cases and not just cases under RSA 265, which is the motor vehicle code. So this bill itself only applies to violations under 265, meaning if you got a speeding ticket, you'd be entitled to receive the body worn camera within 5 days. But if, for example, you got charged with Class B misdemeanor driving while intoxicated, you would then go back to the normal sort of discovery rules, which wouldn't have that time frame associated with it. So it doesn't make a ton of sense to me personally that you get it within 5 days for a speeding ticket, but a more serious crime, you wouldn't necessarily get it within 5 days. I think this also raises questions about multiple charges. You can certainly have a case that perhaps started as a speeding ticket or something under 265, which would be a violation, and turned into something else. For example, if the police officer ended up finding drugs in the vehicle, it could be a much larger stop. And then I echo the sentiments about the penalty provision, that failure of law enforcement to disclose the recording as required by this subsection results in the case being dismissed with prejudice. I'm sorry. My concern is that, of course, in New Hampshire, body-worn cameras aren't mandatory, and it seems like, at least from the introduction when I was here a couple weeks ago, Representative Schur had asked, essentially, how do we encourage police departments to use body-worn cameras? And to me, if you're a police department, a police chief, and you're wondering whether or not I should equip my officers with body-worn cameras, and you're told that if you do equip them with body-worn cameras, you're then under this obligation to hand the body-worn camera recording out within 5 days, and if you don't do that, your case is going to be dismissed with prejudice. It seems to me that does not necessarily incentivize law enforcement to adopt body-worn cameras in general. So for a number of reasons, I am opposed to this bill, and I'm happy to answer questions.
Representative Scheer.
Again, full disclosure, Mr. Enders had the misfortune of also being a student of mine. What's the name of the number of the bill in the Senate that's being worked on?
It's Senate Bill 289.
Thank you.
Representative Lascelles.
Thank you for taking my question. This is not necessarily specific to the bill, but if a police department provides body-worn cameras to their law enforcement officers, I think that video can work a couple of different ways. It can protect the officer, or it can protect the person that's being charged. Is there any statute that disallows a police officer from turning off the camera?
Yes.
There is.
Yeah, so RSA 105 D2 is the state's sort of I think it's a very comprehensive statute regarding body-worn cameras. It requires the police to activate them upon arrival or as soon as practicable. It requires the police to inform the person that they're being recorded. It requires that essentially once the recording is activated, that it be maintained throughout the entire incident. It allows the recording to be muted under certain circumstances. For example, when officers are speaking to each other, whether they're sort of forming a plan or that type of thing, they're allowed to mute it. So there's a fairly comprehensive statute already in New Hampshire regarding body-worn cameras. That statute has a couple of sections. That first section is the creation of the body-worn camera in the field. And then the second sections of 105 D2 deal with how that recording is maintained once it's made. And there's restrictions in that statute on copying, displaying, viewing that body-worn camera, which the legislature put in place because they were concerned about privacy of individuals on body-worn cameras. And then the last section of that statute talks about retention of the body-worn cameras, and in a little bit of a sort of an odd twist. Normally retention statutes say you have to keep it for at least this amount of time. RSA 105 D2 says you must destroy it within certain time frames. So again, I think that's a result of wanting to protect people's privacy and not have these things hanging around forever. there are situations, as the gentleman before me indicated, that if charges are brought, they're held for a minimum amount of time. They're held till the case is over, so to prevent body worn camera from just being destroyed before a full adjudicatory hearing.
Thank you.
I don't see any more questions. Thank you
Thank you.
very much. Is there anybody here wishing to testify on House Bill 146 that has not turned in a pink card? Seeing none, I will recess the public hearing and we will reconvene that next Friday. The committee will be in recess until 1:30 and then we will come back and hear House Bill 698. What's that? Oh, all right. Enjoy your lunch. Good afternoon, everybody. Welcome back. I hope everybody enjoyed their lunch. We are going to open the public hearing for House Bill 698. And I would like to welcome the prime sponsor to introduce this legislation. Okay. When you're finished, if you would not mind just filling out the pink card so our clerk has it for her meticulous records. Yeah. Yeah. A lot of people you can mess with in this, but not her. Do not mess with Allie. If you don't mind, just there you go. Thank you.
Nope, still not on.
There you go. The red actually
red
means
is good.
go.
Okay.
Red means go in this committee.
I got it. So this bill is very simple, and it is
They all
just
say.
it is intended to address largely a safety issue, but to some degree an accountability issue. There have been news headlines over the years in various districts. I haven't seen any in New Hampshire, but I've certainly seen them in other states, where people commit home invasions or commit other acts. They pull someone over for speeding, which becomes a pretext for a carjacking or something, by posing as a police officer. And people can do this just because there are not requirements for identification, or police are not restricted from exercising their police powers only when they're in uniform. So this is a simple modification that says that when an officer is in uniform, everything is the same as it is now. When an officer is out of uniform and he's undercover and it's pre-approved, everything is the same as now. So, I say, let's deal some drugs. You're not a cop, are you? The cop says, no, of course not. And that's fine. And in exigent circumstances, there are no need to hold up your ID before you're kicking in a door or something. However, if someone says, hey, I'm a cop and this person is dressed in a t-shirt and, I need to see your ID, I need your social security number, you can legitimately say, hey, are you actually a cop? Can I see your ID? And that is the only requirement. And so this should not be a problem for any legitimate law enforcement officer. And there should be, the Finance Committee has said that there should be no budget impact, and I'm open to any questions.
Thank you. So when you said about social security number, that was just an example, right? I don't think
It was an
that-
example. It's something I saw in a YouTube channel, The Civil Rights Lawyer, just the other day, where people claiming to be ICE agents asked someone, hey, prove you're an American citizen. Let me see your ID. I'm going to take a picture of it. What's your social security number? And this is a tool for potentially identity theft.
You
And
aren't
so
kidding.
This just gives someone the ability to say, I don't know what the law is. I don't know if I have to ID myself. I'm certainly going to comply with every legal order. Can I just see your ID first? Oh, you're an officer. You're an ICE agent. You're FBI. Great. Now I will answer your questions.
Interesting. Thank you. Okay. Somebody has to have their hand up here. Representative Scheer.
I have to keep my record going. What's the difference between 10428A and this edition 10428B?
I remember discussing that with OLS. I believe the answer is that, could you remind me of the text of A, please?
A says, any person who knowingly and falsely assumes or exercises the functions, powers, duties, or privilege incident to the office of sheriff, and that goes through a whole list, or who wears or displays without authority any uniform, badge, or identification by which, etc., and with the intent of to being recognized as such, shall be guilty of a Class B felony. I'm just trying to figure out
Right.
what we gain with this
Right.
addition.
Just one second. Thank you for the gentleman who shared this with me. So part of it is that A requires the intent to exercise privileges or powers. So I'm putting you under arrest. And this would be just, I just want to have a conversation with you. And, police are allowed to have a conversation, and there's a lot of holdings saying, hey, you were not being detained. It was not an exercise of police powers because it was a voluntary conversation between a citizen and another citizen who happens to be a police officer.
Follow up?
Follow up.
whenever a police officer asks someone, says, I want to ask you some questions, and the person says no, if the police officer then says, well, I'm going to hold you here until you answer some questions.
Yep.
At that point, under the law, the officer, the individual is detained.
I agree.
And the exercise of that authority to detain the person briefly, which they're allowed to do under certain circumstances, I'm just still not sure what we get with 28B.
Sure. So I think, I'm not a lawyer, but I think that might be a Terry stop that we're both talking
is.
about.
Unfortunately, I am a lawyer.
I passed the bar exam by deciding not to go to law school. So there is the whole thing about, am I being detained? And the officer, doesn't answer that, et cetera. And so this is triggered. This bill is triggered in part by an incident that happened to a friend of mine, Jeremy Kaufman, who was at his home, and two people came up to his front door dressed in civilian clothing and said, "We are FBI agents and we have some questions." And I think that Jeremy asked them for identification and they shrugged it off. I and three other representatives wrote to the head of the FBI division headquartered in Boston, which covers New Hampshire, and said, hey, we are state representatives. A constituent of one of ours, an acquaintance of the rest, had this incident where two people, not in uniform, without an identification, who did not give their names, who did not give their badge numbers, claimed to be FBI agents. Can you tell us if these people were FBI agents? And further, can you tell us what your protocols are? I mean, maybe your protocols are explicitly, there's 3 tiers, there's undercover, there's, FBI informant, whatever. Can you tell us if these people were FBI agents and what your protocols are for displaying information or identification when requested? And we got no response. We escalated a few times and asked again, and we got no response. So this is a thing where, in this particular case, this individual was not detained. He was on his front step, but nonetheless, there was a situation. And I suggest that with a law like this in place, there would be no interference with investigative abilities. If these were real FBI agents, they could have said, yes, of course we are. Here are our badges. This would have been useful for Jeremy in this case. He could have taken a quick picture so that if he had a civil rights lawsuit or anything later, he would know what was happening. So, we can also talk about the scenario. We've talked about the one scenario where it's criminals posing as law enforcement agents. We can talk about another scenario where they are legitimate law enforcement agents, either conducting a mission that was not authorized by their superiors or exceeding the scope, knowledgeable in the fact that if the complaint comes in later, there were 2 bearded gentlemen in their 30s wearing clothes. That's the identification. And, in this case, Jeremy did have video, so that provided extra detail. But in many cases, people aren't running their cameras. And especially, it's fairly common for law enforcement officers, with or without legal authority, to tell citizens, stop filming. So you can imagine a scenario where someone is, pulled over or accosted at the street, or they're in Costco, and someone claims to be, immigration control or FBI or whatever, wants to have a quick conversation. Maybe a person, and I've unfortunately been on the receiving end of this, I know what my rights are. I know a Terry stop. I, can ask if I'm being detained or not. I can ask if that's a lawful command or just a request. I can ask if I'm free to go. But most Americans are not fully cognizant of their rights. But, if you, see TV, real citizens know that they do have to be read their rights. This is a fairly simple thing to ask. And similarly, in New Hampshire, can I see your ID is a very simple thing. And at that point, maybe the actual law enforcement officers showed their ID, but become cognizant of, hey, he knows my name now. I'd better play it by the book and follow regulations. Or say, this is, I've gotten out over my skis. I'm doing something I shouldn't. And they turn and walk away. And even in that latter case, that would be under this a crime to say, I'm a law enforcement officer. I'm, giving you a command, or, I want to have a conversation, but then scurrying away. So this would, bill, if passed, would serve as a deterrent to that sort of behavior, which does in fact happen.
Follow up. I'm a law enforcement officer. I give you a command. I'm a fake law enforcement officer. Thank God for everybody. And I give you a command to do something. to me, that's covered by 10428A. If I'm a person who falsely is knowingly and falsely exercises the functions of a police officer.
I agree with you. So my hypothetical where I included the statement gives a command muddied my hypothetical and brought it into something that is in fact covered by A. So I again want to talk about situations where there is not an explicit command, but merely someone claims to be and uses that as sort of implicit pretext. And there's a lot of case law where judges at a great remove and with their sort of socioeconomic privilege can say, well, anyone who's, sat through torts or criminal law 3 or whatever would realize that the correct thing to say at this juncture is such and such. And the citizen did not walk away from the police officers. Therefore, the citizen was indicating that he was fully voluntarily engaged in a mutually agreeable activity. I think that those hypotheticals miss a lot of the sort of emotions and subjective experience that happen with facts on the ground and, normal people engaged in interactions with people who either are or who claim to be law enforcement officers. So if I can adjust the hypothetical to, remove the command and just, hey, I'm from ICE. I want to, not a command, but I want to see this. Can you tell me where you were born, et cetera, et cetera. Is a thing that does in fact happen both with legitimate LEOs and non. Thank you.
Everybody good? All right. Seeing no further questions, thank you very much.
Thank you for your time.
Major Davey.
Good afternoon. Ladies and gentlemen, I appreciate your time. My name is Brendan Davey. I'm a major with the New Hampshire State Police. I am the commander of our Operations Bureau. I'm here representing the Department of Safety in objecting to this bill as written. The line of questioning has already revealed to some extent that the law, if enacted, that this law would be largely obviated by existing law, unnecessary. There are also issues of exigency not addressed by this law, in that the exercise of police power is, in many cases, bereft of opportunities to exchange identification, things of that nature, particularly when to do so is to expose the officer who may be off duty in an official capacity at the time that these interactions could occur. And furthermore, there are situations in which we use our undercovers to track, to tail, as it were, and to confront, in some cases, very dangerous people who, at the sight of uniformed police officers, would behave in manners that would subject themselves and the officers and others to unjustifiable risk. The notion that a police officer would approach someone and ask them for their social security number, I find very, very unlikely in this state in particular. And I would add to that two things that were addressed: the profession of law enforcement as a profession largely controls the behavior of its members with standard operating procedures, many of which are akin to the one that we have in the New Hampshire State Police, which includes, when asked for our name, our badge number, as it were, then we're to answer for those things. The idea that filming would be, that a person would be told to stop filming, that's a very well settled matter of law within this state. I'm a public employee. You can film me as long as you like, provided that it doesn't subject us to unnecessary risk, basically, or get in the way of the lawful activity. So that is those are my responses to matters spoken and the department's view on this proposed legislation.
Thank you very much, Major. Representative Newman.
I just have a comment about the comparing this bill to the current law. And the current law talks about any person and then says they do this and displays a uniform without authority. This bill says any person while not wearing their official uniform. See, so to me, I think that narrows it down just to someone who has a uniform or has an identification, just the wording of it. I'm wondering if that would just narrow this down from any person. That wording might narrow it down just to someone who has those documents and clothing. And
I understand your point, sir. I can answer with an experience that I had of arresting a drunk driver in my neighbor's driveway after he got stuck there after making a 100-point turn in my other neighbor's driveway. It was a Friday night. It was 10 o'clock at night. I ran out there in my jeans and T-shirt with my gun on my hip and convinced him more by virtue of my conduct that I was law enforcement. But had I been required at that point to show him some ID and satisfy his demand of me to prove who I was at that point, we would have had a different kind of situation, more of a stalemate, I suppose. So your point is well taken. And generally speaking, we do have ID with us, and we do let people know who we are without delay.
follow up?
Sure.
Yeah, just a follow-up comment to that. I wasn't trying to apply what a police officer might do or might not do.
Yes, sir.
I was trying to say that if this bill replaced the other one, it would limit it to people that actually had a uniform and had whatever. It could be the only people that would be subject to the new law, where the other one includes any person that tries to impersonate an officer.
Mm-hmm.
Anyway, I'll leave it at that. Thank you.
Yes, sir.
So Major, if I may ask, how would this affect an officer, maybe an off-duty officer, you know the famous movie scenes, right? You're at the diner, and Pulp Fiction, right? You're at the diner and something's about to go down. Tell her to chill. And now what would happen? What would happen? What would happen? Because you're not in uniform, right?
Right.
But you're clearly an officer, and now you have this duty. How would this affect that? Or would it not?
The way that I read it as written, it places the burden on me to prove to that person before they will submit to my exercise of authority that I am a person vested with powers that they ought to recognize and to obey in order for their conduct to be either lawful or at least not unlawful further.
Okay.
So it's that's really the issue, is in the midst of an evolving tactical situation, to say you just keep your hands where they are and then I'll produce my ID for you is an untenable circumstance to be in. Furthermore, the courts have ruled that merely to speak to people in public under certain circumstances can be viewed as a detention. And so the extent to which we walk by someone on the sidewalk and just talk about the weather and say hello and leave it at that, versus ask a question about the fact that we're in a business that's closed and it's at night. Those are all issues that are always taken into consideration by the courts. So what is, at the end of the day, an exercise of power is, or authority, is very carefully scrutinized by the courts. So at what point, in reality, my exercising my authority would then be subject to I satisfying the curiosity of the person who is subject to that authority, that I am who I say I am. That clearly is problematic.
Okay. All right. Hold on. No, don't say it. Stop. Wait, I got it written down. Representative Saborn D. Schwanner.
Thank you. Thank you, Madam Chair. Sir, thank you for my question. Is there already an anti-harassment law on the books that might cover this already? Like the example that was given, no, that certainly by Representative Corcoran, that it was definitely harassment. Is this adding to that? Would this be adding to that?
A law, I'm not sure. I can say with confidence for people who wear this uniform to have conducted themselves in that way would subject them to at least internal repercussions. Whether or not the conduct was illegal based on the description, it strikes me as impersonation, and clearly there's a law that makes that illegal, but harassment, I'm not really, the harassment statute that we have, no.
I've been informed that this is an addition and not a replacement.
Yes, sir.
And so I'd like to go back to the scenario that you described. And looking at this, in the instance that you described, since this says any person not wearing their official uniform, so they don't have, but they actually do have, if it says without their official uniform, it says the person must be someone who has an official uniform and then fails to wear it and fails to provide identity, would then be subject to a Class B felony. And I think that language is just kind of crazy. Because it limits it to the police, and I'm not sure what the intent to accomplish with this. Because it also goes on and says to say, it has a carve out for any officer who is law enforcement and engaged in undercover activity. So I just think this is all about official police that don't produce their identity or wear their uniform, and I just don't think that this would be enforceable or wise. Do you agree with that, or do you?
I do, sir.
Yeah. Thank you.
Thank you. Well, and it engaged in legitimate, who determines what's legitimate, and the pre-approval, approved by whom. So it's there are some issues. Yes, sir.
Thank you very much, Major. I think we're on the same page.
Thank you, madam.
Thank you very much. Is there anybody else here that wishing to testify on House Bill 698 that has not turned in a pink card? Seeing none, I will close the public hearing. And let's see, we have about, looks like 7 minutes until 2 o'clock. Our next hearing will be House Bill 162. Members, we have approximately, hold on one second. All right. Okay. So, all right, welcome back. We are going to open up the public hearing for House Bill 162 and welcome Representative Scheer to introduce the bill.
Thank you, Madam Chair. I'm Representative Buzz Scheer. I am from Rockingham, District 26, Portsmouth, Ward 3. Not incidentally, I'm also a police commissioner, elected police commissioner in Portsmouth, where the 3 elected police commissioners are the board of directors for the police department. This bill is the next step in a process that began 3 or 4 years ago when Representative Roy and then Senator Harold French introduced bills, one in the House and one in the Senate, to require written informed consent when an officer when an officer searches a car, if the person agrees to have the car searched. And alternatively, it required the officer, before an individual made the decision about whether to consent or not, to inform them that they had a constitutional right not to consent, and that their refusal to consent to a search of the motor vehicle would not be held against them in any way. That was the substance of that bill, and it passed through both the House and the Senate, I believe on consent calendar, if I'm not mistaken. And this is the next step in that bill, where we just include all searches of property where an officer is obtaining consent to search. It's like, effectively, I think Representative Roy referred to it when he testified on the earlier version of this. He referred to it as basically giving people who are being asked to consent to search something akin to Miranda rights. It's not just here are your constitutional rights as to whether you have to consent to search or not. And so this is the next step to finish off that the scope of that bill. I can only speak for Portsmouth Police, but I talked with the chief there, and this was a non-issue for him. I think many police departments already do this. So there's the substance of my testimony.
Thank you very much, Representative. Any questions? We're good? Representative Murphy?
Thank you.
She can't resist.
Can you tell me, thank you for taking my question. And in all fairness, I haven't read this, every single line of this, but what, would this bill as written preclude the ability of law enforcement to, if a person denied access to the trunk of their car, what if, and I'm just thinking hypothetically, they kidnap somebody and they're in the back of their back of their car. Law enforcement, if the person then says, no, you can't search my car, law enforcement then needs to get a search warrant, I'm assuming, correct?
In most circumstances, there can be circumstances where law enforcement, if they have probable cause to search the car, they may not, under certain circumstances, need to go get a search warrant. But what they could do if they needed to get a search warrant, again, this all depends on the circumstances. They could seize the car temporarily while they went and got the search warrant. Okay. But this doesn't get in the way of that process. This just says when they're looking for consent, they have to let the person know that they have a constitutional right not to consent. And if they decide to consent, get that in writing or on a body cam. So this doesn't get in a way of anything a police officer could do based on knowledge they had to get into the trunk of the car without consent.
So should a person not consent under these like exigent circumstances, the police officer can still get into that truck?
Yeah, I'm too much of a professor, so depending on the specific circumstances, yes. Sometimes they'd have to get a search warrant. Sometimes they wouldn't. I just want to be accurate in describing the law, but this doesn't get in the way either way of that.
Thank you.
Representative Muse.
Since this bill encompasses, it looks like it encompasses all property. Would that include things like electronic equipment, like computers and cell phones?
Yes, I mean, it's already, the U.S. Supreme Court has already decided that even if the police found your cell phone on the side of the road and could pick it up as what seemed to be abandoned property, or they came across your cell phone legally through a search incident to arrest, which they're allowed to do, the U.S. Supreme Court has said, nonetheless, to get into the cell phone, they need to get a search warrant. Unless they have consent. I mean, they could get consent, and that's what would apply. This would apply to. They would have to say simply, you have the right not to give us consent, and if you do give us consent, please sign up here. If you decide not to give us consent, we're not going to hold it against you. Doesn't get in the way of them getting a search warrant if they have the necessary probable cause.
All right. Seeing no more further questions, thank you very much. Oh, I didn't see your hand. I apologize. It was an accident. I'm working on it. Representative Gathright.
I feel like an irresistible target.
Can we go to line 18? Says a significant period of time shall mean the person and the law enforcement agency involved has ceased to interact with one another, and a new set of circumstances or facts have arisen that justify a new interaction. Can you explain that to me or give me an example?
Yeah, I'll give you an example of a U.S. Supreme Court case. Please go up to a house. Husband, they want to search the house. They don't have probable cause. They don't have a warrant. They can't get into the house. The husband and wife answer the door. The husband says, they ask for consent to search the house, to come into the house, and the husband says no. The wife says yes. U.S. Supreme Court said, if one person says no, that's enough. The police then detain the husband short time later for other reasons and take him away. Then they go back to the house and ask for consent from the wife, and she consents. And they find a bunch of incriminating information. U.S. Supreme Court said that's fine if the person is spirited away. There are circumstances where the police may return to the house, or they may acquire further information, and they may come back and say to the individual, hey, we know this now. Now do you want to let us consent? And if the person says, they've got to inform them again of these rights. But what that language does is it tries to prevent the police from
getting a warrant,
coming back. Well, no, it doesn't try to prevent them from getting a warrant. They can always get a warrant. It tries to prevent the police from just coming back every 10 minutes without a change in circumstances to keep trying to get consent. Trying to put pressure on in that way. That's what that language is intended to account for. So that doesn't happen. It's fine if the circumstances are changed. They can come back and ask for consent if they want, or they can go get a search warrant if they want. But we don't want them coming back every 5 or 10 minutes to keep trying without new information. That's a form of intimidation that this tries to deal with.
Yes, sorry. Thank you.
Thank you.
Where's my mic?
Good afternoon. My name is Stephen Enders. I'm an assistant county attorney in Merrimack County. I've been a prosecutor for over 20 years, and I do oppose this bill. In New Hampshire, all searches have to be conducted pursuant to either a warrant or an exception to that warrant requirement. Consent is an exception to the warrant requirement, and consent, that exception has been developed over years through case law. As Representative Scher indicated, he cited a number of Supreme Court cases. This is something that, again, has been developed through case law. Under our current case law, there's no requirement to inform a person that they have the right to refuse consent. Under our current case law, there's also no requirement that any type of written form or anything like that be required. As Representative Scher said, this is sort of like a Miranda for consent, but this actually goes much further than Miranda rights go, because currently in New Hampshire, there's no requirement that Miranda rights be written down or that we have a form formally waiving them. So this actually goes beyond that. It doesn't just require it to be informed. It requires that informing to be in writing or on body-worn camera. That creates difficulties because there may be times when the officer doesn't have the form with them or doesn't have a body-worn camera, and then would simply be precluded from asking for consent because you don't have a form. The language in the bill itself is actually, I think, confusing, and I say that because under current 595A10, which is a statute I'm certainly not in love with, Section 1 that starts on line 5 says a law enforcement officer may legally conduct a search of a person's home or any other property, including a motor vehicle, without a warrant if the law enforcement officer expressly informs the person of these two things. It seems odd to me that it doesn't actually require the person to consent. It just requires the officer. It says the officer may legally conduct a search if you say these two things. Certainly that's not what it means. It means you actually have to have the person agree to consent, but it doesn't explicitly say that. The form itself, under paragraph 3 at line 24, says that the form itself needs to provide notice of the provisions of paragraphs 1 and 2. So the way this ends up working is if this passed and it came to me, I'd be tasked with creating a consent form for the police departments within the county. And I can tell you that what I would do is simply cut and paste paragraphs 1 and 2 so that there was no question that my form complied with the statute. If I did that, my form's going to include the language in paragraph 2. If you refuse to consent to a search, the law enforcement officer shall cease any further questioning concerning consent to search unless a significant period of time has passed or you raise the subject of consent. A significant period of time shall mean the person and law enforcement agency involved have ceased to interact with one another and a new set of circumstances or facts have arisen that justify new interaction. I think that just becomes very bulky and confusing on a form. The other concern I have about this bill, and it's similar to the concern I expressed before, is that there's this exclusionary provision in it that says any search that violates this section will result in the evidence being excluded. What concerns me about that is the exclusionary rule is a fairly severe remedy that is employed for constitutional violations. Whereas here, we're not talking about necessarily a constitutional violation. We're talking about a statutory violation. If the officer doesn't use the right form, doesn't have a form, but does in fact obtain what would normally be regular good consent, we're suppressing all the evidence as a result of that. And I think that certainly excluding all evidence is a major hurdle for a statutory violation. I'd be happy to answer questions.
Thank you very much. That was actually a very nice explanation. Thank you. I was
Thank
trying
you.
to write as quickly as you were given the information. Anybody have any questions? We're all good? All right, looks like we're all set. Thank you very much.
Thank you.
Appreciate your time. Is there anybody else that is here that wishes to testify for House Bill 162 that has not completed a pink card? Seeing none, I will close the public hearing. And before anybody leaves, our next hearing is at 2:30. But Representative Gathright and I discussed it, and we think it'd be a good idea to just do an executive session on House Bill 698. So we're going to give the clerk a second to just grab her papers.
I'm just curious as to, oh,
Welcome back, everybody. We are going to open the public hearing for House Bill 468, and we welcome Representative Wheeler to discuss this legislation.
Thank you, Madam Chair, friends and colleagues on the House Criminal Justice and Public Safety Committee. For the record, my name is Jonah Orion Wheeler. I represent the towns of Peterborough and Sharon, Hillsborough's 33rd District. I am a sponsor on HB 468, and I'm here to fill as Representative Rhodes said, the big shoes of Representative Roy, who I'm sure is watching at home, and I hope I do a good job for him here today. I was already planning on testifying, but now here I am introducing the bill. So I'm happy to take any questions that you may have. HB 468 addresses a gap in the law around the regulations for use of an unmanned aerial vehicle and a drone. These drones are being used a lot more often, as we saw in 2024, November 13th to now. They're still being seen in the air. There was a significant increase of drone incursions over the East Coast, the West Coast. You saw on December 13th and December 17th, Wright-Patterson Air Force Base in Ohio was shut down because of these drones. On 11 December, a Chinese national was arrested outside of Vandenberg Air Force Base for flying one of these drones. The legislation sets up a tiered system whereby somebody who was flying a drone unlawfully against FAA regulations for their first time would be guilty of a violation for the first offense, a misdemeanor for a subsequent offense. That's found on lines 12 through 15. The next paragraph outlines the system by which, if someone is interfering with human-occupied aircraft or otherwise impeding the normal course of operations of international, regional, municipal, or general aviation airports, that person would be guilty of a Class A misdemeanor and a Class B felony if such operation resulted in the damage of a human-occupied aircraft, and a Class A felony if that resulted in the damage of a human-occupied aircraft alongside serious death or injury. So I think this tiered system that we have set up here is pretty moderated. I think the penalties are appropriate for the crimes that they have committed. If you're flying a drone in airports, airspace, and your drone, people think, oh, it's just a small drone, it's no problem. But if you know anything about aircraft, air travel, if that plane's coming down at 100 and some odd miles an hour, 130-ish, and they're about to land, and a drone is in its flight path, that drone could go right through the fuselage, right through the engine, and create some very serious problems. And we've seen that happen in the instances in which a drone has crashed into a plane or something or the other. So this is a serious crime. The skies should be protected and open. The United States, I think, loves its air travel. We should be making air travel safer and more secure, and not littering our skies with these drones that are operating in many instances illegally. So happy to take any questions about this piece of legislation and the specifics around it, but I hope at some level that the committee is able to find some way to fill this gap, and I think HB 468 fills it properly. Thank you, Madam Chair.
Thank you, Representative. I believe you covered it, but I just wanted to clarify, if I may. So when we had this legislation last term, I believe it was a Senate bill, and Representative Newman actually got us a very quick amendment because I think, if I'm not mistaken, it went like misdemeanor, felony, and we wanted to make it violation, misdemeanor, felony. And then our other friends came back and they didn't do that, and I did away with it on the House floor, and may have been heckled by that by some of my other friends. So this is now addressing the concern that we at least had in this committee last year of let's step up the ladder instead of, going over.
Jump off the cliff.
Jumping.
Absolutely.
Yeah, right.
Absolutely, Madam Chair. I remember that legislation, and I thought to myself, why is the Criminal Justice Committee dealing with drones and unmanned aircraft here,
I
but it
thought the
actually
same thing.
became clear in research that this is something that's, and I think, yes, this legislation addresses the concerns that we had on this committee last biennium and moves us forward in a way that hopefully we won't have to throw it off the cliff again next year.
Thank you. Thank you, Representative.
Thank you.
Representative Saborn, yeah, you.
That was a good try.
Thank you, Madam Chairman.
I have to keep my note out that tells me how to say it.
Representative Wheeler, much simpler last name, by the way. So the only restrictions on flight, anywhere it appears, it's just you can fly your drone anywhere except over a federal, state, correctional. Item number 4, correct? That's the only restriction.
That's
where they can be flown.
That's correct.
Okay.
Or otherwise regulated by the FAA. So you can fly it at your house unless your house becomes an FAA no-fly zone for some reason or the other, you know. But
All right. Thank you.
if you live near an
Representative
airport,
Muse?
right?
Would the bill encompass flying a drone over private property you don't own?
That's a good question, Representative Muse. I would say that if you fly, that would be a different piece of the law than the law trying to protect the aircraft and the airspace itself. I would be interested in trying to address flying drones over private property when you don't have the permission of that person who owns the property. And I know that came up in the conversations last year. How do we identify what drone, where that's coming from? But I think that would be maybe a separate piece of legislation, but happy to whatever you and the committee feels is necessary on this.
Thank you.
Thank you.
Prue?
Would you believe that when I was on eDNA, we addressed a lot of those things about drones flying over people's houses and taking pictures? You take pictures as long as they were not recognizable, if I remember correctly.
I would believe that, and I'm going to have to do some more research.
Representative Shear?
Do you know if the commercial entities that sell these drones accompany the sale with some notification of what the FAA regulations are? I mean, you know, I'm a little. My guess is the average layperson who may buy a drone because it's kind of fun and interesting, they have no clue whatsoever what the FAA regulations are.
I would say
Ignorance is not an excuse.
that's absolutely right. And I would say I've never bought one of those drones that are very expensive. I haven't even looked because they're so expensive. I know I'm not even going to give myself, you know, I'd love to have one of those drones, so I'm not even going to look. But what I can say is there are tiers of those drones. I do know that. And the drones that are readily available are oftentimes not the ones that would stay up long enough or be able to fly high enough to cause these kind of problems. And I guess I would say, like Representative Rhodes said, I keep wanting to call you Representative Roy because that's the name tag right in front of you. But like Representative Rhodes said, that there you go. Not knowing is not a reason enough not to be compliant. If you're choosing to fly an aircraft, you should know that there are regulations for our skies, and especially if you're living around an airport or an FAA regulated area.
Yeah, I'm not so concerned with the living around an airport or a penal institution or house of corrections.
Follow up, Representative Shear?
Follow up. I'm sorry. My concern is, you know, the paragraph 2. I mean, you know, and I know that probably most of the people that buy their first drone have no clue what the limits are, and it would be, you know, as a matter of notice, it would be nice to have. Do you think it would be nice to have them be aware of what those regulations are?
Absolutely. And as you were talking, I was thinking of myself, you know, conversation that I had with Representative Harriet Goth right outside before this. She asked, where is the feds on this? And I would say that's something that the federal government should encourage companies which are producing these drones to make sure that there is a notice that says you should follow and comply with FAA regulations if you are to fly one of these aircraft.
Thank you.
Thank you.
I would be interested to see how many people actually read the notices. You know, don't remove your
How
tag
many
from your
people read the
mattress.
nutrition labels, right?
Right?
So, yeah.
Representative Newell?
Thank you, Madam Chair, and thanks for taking my question.
course.
I'm just curious and looking through. So the difference between a Class B felony and a Class A felony is, just to quote really quickly, a Class B felony if such operation results in damage to a human-occupied aircraft in flight, and then Class A felony is if such operation causes said aircraft to crash and such crash results in death or serious bodily injury. So what's interesting to me about that, and I would love for you to comment on it, is the difference between a Class B and a Class A is whether serious bodily injury is, it's not the, if you cause, let me try and say it better, because I would think that regardless if you caused a manned aircraft to crash, whether or not the person sustained serious bodily injury, I would think it would be the same level of felony. You know what I mean? So the separation is in what harm came of it to the individual rather than the fact that you could have caused that harm. It just didn't happen to happen. You know what I mean?
I think yes. And I would say the Class B felony is just such that you would be guilty of a Class B felony if the human-occupied craft were damaged but still flyable. So there are instances in which, you know, a drone could hit a craft. That craft could still land properly and that person would be fine, in which case Class B felony. But if the drone or whatever aircraft is being operated crashes into the craft, that craft then crashes, it's human occupied, then that person would be a Class A felony. I think that's where the distinction comes. If the craft can still, if it's just damaged but it can still land, it hasn't crashed, then it's not as high as a Class A felony. I think that's where the distinction came in. But I'm not the drafter for it.
Can I follow up real quick? Because the place where it says crash is in section C there, or the, you know, that clause,
Yep.
where it's talking about if it causes it to crash and the crash results. So it's just interesting to me that it's separated in that way, because I think if it crashed and didn't cause, because the and is in there, if it crashed and it didn't cause serious bodily injury or a death, then it would still be included in damage, the way that I'm reading it. Maybe I'm,
Okay, I think I see what you're saying now. So you're saying a person would be guilty of a Class A felony if the operations caused the aircraft to crash, and if that crash resulted in death or serious bodily injuries. I would still say that those are different than the Class B felonies, because the Class B felony is such that it's just damage of the aircraft. The Class A felony comes when that aircraft crashes and such crash resulted in death or serious bodily injury.
okay.
I'm happy to talk with you a little bit more afterwards about this.
Thanks.
Representative Prue?
Oh, yeah. So I do believe that when you buy a drone, the basic federal FAA warning is in the box. You can only fly so high. You have to be so far away from an airport or an exclusion zone. Yep.
Representative Muse?
One of the things that we talked about when we talked about similar bill last year was sort of the weaponization of drones. So the bill, it doesn't look like it would cover things like somebody flying the drone into a person, like injuring a person intentionally with a drone, releasing a package that would injure a person, you know. And I know in Manchester there was an issue with somebody dropping feces on some homeless people with a drone. In Ukraine, they're dropping things that are a lot worse on people. And so that's that the technology is for this has really kind of come a long way in a year, and the ability, you know, to actually do harm to people. I mean, one of the things that just occurs to me is in the part where we make a Class A felony, in addition maybe to causing the aircraft to crash, you know, and having that result in serious death or bodily injury, it could be the intentional misoperation of the drone itself, you know, or the use of the drone, you know, to basically harm another human being. It seems like would be an appropriate addition. I'm just wondering what you would think of that.
I would agree. I think that would be an appropriate addition when you see those videos of the people in the trenches in Ukraine and they're just sitting there, and then the buzzing of the drones around. I mean, drone warfare is one of the most horrific things that we're seeing these days, and the weaponization of these drones is definitely a concern.
Representative Prue?
It is already unlawful in the state to weaponize a drone.
Thank you.
Would we believe that it's already illegal in this state, Representative Prue? Would we believe that it's already illegal?
Yes, we would believe.
Thank you, Representative Prue. All right. Representative, so close. Representative Shear.
I was provoked by Representative Prue. It would it would be if somebody ran a drone intentionally into a person and injured them, that would be a simple assault. If they caused serious bodily injury recklessly, it would be a Class B felony, etc.
Thank you. Guys, remember, we're supposed to be asking questions. Okay. Representative Wheeler, you're all set.
Thank you very much,
Thank you.
Madam Chair.
Commissioner Hanks? Welcome.
Thank you.
Nice to see you.
Nice to see you as well, Madam Chair. For the record, my name is Helen Hanks. I'm the Commissioner of the Department of Corrections. I'm here in support and thank the sponsors of HB 468FN. You'll find in my testimony, I won't read it because I know you will read it and take your time to review the information I provided to you. I have been working for a number of years to both at our federal level and supporting at our state level, all the work to protect our correctional facilities from, I'm going to use the term drones. You'll see numerous examples in other states where drones across the country are dropping drugs, firearms, cell phones. We do not have drone detection in New Hampshire. When we see a visual drone, we shut down our yard. It is chaos. We look to see if something's been dropped. We're using, our cameras and our human eyes. It is a challenge. It is unsafe. And I share that because there should be a consequence. And we are mindful of individuals who do it unknowingly. And we work with our state police partners and other partners in the state to help us identify the operators of those drones when we can. But they are really upping the game in our correctional spaces across the country where these contraband items have resulted in loss of life, dropping firearms that are used to actually end the life of individuals who are working in these institutions. In Georgia, in Idaho, a cell phone was dropped to use for escape that was successful. The list goes on. And these protections are appropriate when these drones are used with criminal intent and the intent to make things unsafe. So I thank you for this opportunity and would also share we did have a free pilot with a drone partner and it was literally free, which was nice. And we did identify at least 3 drones that had been flying over our correctional facility on our southern campus here. And they did it unknowingly and we coached them, but we really, again, need this type of support. I would be mindful, I do not oversee county jails, but I would point to line 26 and ask this honorable committee to determine if it covers our county jail partners in this form of legislation. And with that, avail myself for questions.
Thank you. We'll make sure we make a note of line 26. You said just to make sure that they also cover county facilities. Is that what you said?
I would hope that this committee would want to provide that type of resource to our county jail partners.
Thank you.
Thank you.
Representative Shear, question? You have a question, right?
Yeah, I think I do.
Thank you.
You mentioned drone detection devices or systems. Are there such things, and how much do they cost?
Representative Scheer, there certainly are, and they come with all different price tags. I can follow up with some cost information. Some capital budget proposals ago did ask for that type of support. We were offered different type of relief we asked that fiscal year, but I will get some updated quotes for you.
Do you have a follow-up? Do you have a broad range of the price spread on those?
Representative Scheer, I think if I gave you a number, I would be throwing a dart, and I'd feel more confident if I had more time.
Fair
I
enough.
appreciate it.
Thank you.
Any other questions? Yep. Representative Prue?
In those systems, do they have a way to take the drone down?
My understanding is some of them do. Some of them do. I have not had that validated to me.
Yeah,
They definitely identify where they are, and before they come into your secure perimeter, and you can then reverse engineer the information to identify where the operator is coming from. But your question is really important, and I've been told that they do, but I'm not
I
confident.
think they do.
Yeah.
Anybody else? Thank you very much, Commissioner.
Thank you, everyone.
Thank you for joining us
Be
today.
safe in your travels.
Christopher Bell? Beal.
Mike.
Oh, is it Ball?
Madam Chair, thank you. Yeah, last name is Ball. B-A-L-L.
Let's just make that U and A, shall we?
Whatever works for you is fine with me. I get all different different versions of it, so not offended in the slightest. My name is Christopher Ball. I'm here to represent the Department of Safety, specifically State Police. I'm a member of our aviation unit. And I just want to take a few brief moments of your time to discuss this legislation. Representative Wheeler and our counterparts at Department of Corrections, I think, have done a great job so far laying the groundwork. So I just have a couple additional things to add to this. One thing right off the bat is that this legislation has been a collaborative effort amongst all departments in the state here, including Department of Safety, Department of Transportation, Department of Corrections. It's been a cumulative effort over the past 2 or so years to put this legislation together with perspectives from different viewpoints, not only from the state side of things, but also our public partners and private partners as well, to really draft and come to a agreement on the wording in this legislation to make it comprehensible, but also fair across the board for everyone's given different viewpoints. With that, there is one at least technical correction or amendment I'd like to propose for the legislation that's before you. I do have copies, I think, available for all the members here of the committee. I've highlighted the area that we'd like to add some language to. It's just a brief paragraph reference to including a penalty for violating the operations of law enforcement or firefighting or other emergency responses in New Hampshire. And I'd be happy to pass that around if that would be appropriate.
If you just want to hand that to Representative Scheer, I'm sure he'll be happy to pass it down for us. Thank you.
And if there are not enough copies, be happy to make some more and certainly send them your way. So that you'll notice when that comes around, there's a highlighted paragraph. It's paragraph 2 in this draft of language, and that reads: a person is guilty of a misdemeanor if such person operates a small UAS that interferes with law enforcement, firefighting, other emergency response operations, or violates any provisions of RSA 644-9. In 644-9, the New Hampshire RSA is speaking to our Privacy Act. So we just wanted to make sure that language was at least considered and possibly included going forward from this point. So just going back a little bit, again, this is like a cumulative effort on the part of many stakeholders to get this legislation before you. And essentially what this legislation does, it gives New Hampshire law enforcement a tool to fall back on. As Representative Wheeler mentioned, really at this point in time, there is no New Hampshire law regarding UAS or nefarious UAS operations, and that really ties the hands of New Hampshire law enforcement currently as it stands. So this would give a option for law enforcement if they do encounter individuals who are using these for nefarious purposes, either criminal intent, recklessly, or carelessly. Obviously, with the mindset that any enforcement action would probably be predisposed to any some kind of like education along the way. So prior to taking enforcement action, there'd be some education involved. So the idea, at least from our perspective, is not to take enforcement action broadly, but only when it's specifically needed. And this would give law enforcement in New Hampshire the ability to do that when those situations call for it. As Representative Wheeler had mentioned, there's been a number of incidents across the country, globally, and even locally, involving the nefarious use of drones or the reckless operation of drones, and that's why we think this legislation in New Hampshire is so important. And with that, I'd be happy to take any questions.
Thank you very much. Representative Paquette.
Thank you. I was just wondering if the amendment that you just offered would include like media related drones and things.
Just so I understand the question, so media outlets that may be flying drones over a scene or something like those lines?
Correct.
Okay, yes, absolutely. That is not the intent to restrict that from happening, only if that conduct was interfering with the emergency operations. For instance, a recent event in California with the wildfires, a firefighting aircraft was struck by a drone, and that obviously deterred that aircraft from helping put out a fire. So things along those lines is what we'd be looking at preventing with this legislation.
But it wouldn't.
Yeah, you're good.
Sorry, but it wouldn't restrict media from, doing their job at some sort of scene, fire scene, emergency scene, something like that.
No, it wouldn't. Only if it was interfering with the operation of that scene.
Thank you.
You're welcome. Thank you.
Just so everybody's aware, I know we have some new members. What Mr. Ball has been kind enough to give us is not actually an amendment. It's just some suggested verbiage that he thinks might be helpful for us to add to the bill if an amendment is done. Representative Muse.
Would you be open to changing your suggested changes in the language so that we could draft something that doesn't actually preclude the media from filming these scenes? I think putting guardrails around it is one thing. When you eliminate it, it's a freedom of the press issue.
Yes, yeah, we would be open to that, and certainly it's not the intent, at least from our perspective, to preclude media from doing their jobs.
Thank you.
Anybody else? We good? Okay. Thank you very much.
Thank you.
Jason Levitt.
Thank you, Madam Chair. My name is Jason Levitt. I'm with NHDOT. I'm the UAS planner, and I'm actually here to provide technical information if needed. And I would request that I could bring my Bureau Administrator, Tricia Lambert, up.
Certainly. If you could just please introduce yourself for the committee, and you guys are certainly welcome to do this together.
Sure. My name is Tricia Lambert, and I'm the Bureau Administrator of the Bureau of Aeronautics for the New Hampshire Department of Transportation. And as Jason said, he is our UAS expert within the department. I guess I'll give just a quick brief overview for those who aren't familiar with our office. We are the regulatory agency for all things aviation in the state. We are the liaison to FAA for pretty much everything: aircraft accidents, UAS, airport development. So I don't want to repeat what Trooper Ball had said. We have worked together as a group to develop some language that would hopefully be one of the first to provide some kind of guidelines to the use of UAS. Full disclosure, we are an agency that promotes aviation. So we are very much involved with the education from children, students, all the way up, and that is one of our charges. So working together with these partners were to help to try to make it more safe and to allow law enforcement to have some guidance on what they could do for those who are nefarious. and those who tend to be repeat offenders. So that is our goal. We're here to answer any of those questions. I know you had some questions, maybe some technical questions. We're happy to answer those.
Thank you very much. Everybody good? We get it all covered? All right. Wow, looks like you guys got off easy. Thank you.
Thank you very much.
Is there anybody else here that would like to testify on House Bill 468 that has not turned in a pink card? Seeing none, I will close the public hearing. And we are in, our next hearing is at 3:30. So close that. Okay, at this time, we are going to open an executive session for House Bill 162, and I would recognize Representative Prue to make a motion. I don't know. Wait, I'm sorry. I made him. It was the wrong bill number. I'm so sorry. Executive session for House Bill 698.
That's someone else's.
That is definitely okay. Anybody want to make a motion? Representative Murray.
I make a motion to ITL.
Hey, I'll second that.
Okay. Representative Murray, would you like to speak to your motion?
I think that this bill is unnecessary and will interfere with law enforcement's ability to execute their duties.
Representative Prue, would you like to speak to your second?
Ditto.
Does anybody have any open up for discussion? Any comments? Representative Saborn-D Schwanee.
I
know, right?
I know we chatted before, but I think it's, I know we just heard it. I'm wondering if we could maybe do an amendment for it, but I know there was some, I think the crux of the matter is how would this affect off-duty cops responding to an emergency and yeah, I guess, yeah. It's fine.
So Representative, one of the, I think the sponsor's intent is actually well heard. And I think I speak for everybody when I don't think that fell on deaf ears. I just don't know that this is the avenue to address the concerns that he had. And I'm also not really sure what that avenue actually would be, right? So if if an officer is an officer and they're doing something illegal and the intentions of that, something illicit, that obviously is illegal and would need to be addressed. And I'm very confident that the leaders of those departments would handle that the best that they could. I really don't see how this could be executed at all, but I might be misunderstanding. Representative Scheer is going to be very happy to help us out with that.
Now I could
Yeah,
talk forever.
the floor is yours, Representative Scheer.
I think
For a few minutes, anyway.
I'll be very brief. I think this is so poorly written that we have no idea how it overlaps with 104:28A, which it's added to. And if there is I'm still unclear what the purpose of what he was trying to do is. If he's trying to, it's unclear to me whether he's trying to prevent off-duty officers from doing the kind of thing the example he gave of two people showing up at somebody's house and saying, I'm an ICE agent, or whether he's trying to prevent people who aren't law enforcement in any way of doing that. And I don't think the way it's written
it's even clearer which he's trying to address, and that's my problem with it.
I would agree, Representative Knoll.
Thank you. I think also, just to add to that, it is very unclear. It seemed pretty duplicitous, but also considering the fact that it's that unclear, anyone who are guilty of this is guilty of a Class B felony, which is a serious offense. So at the end of the day, if we're going to be saying that we're going to hold somebody accountable, much less law enforcement accountable for, something like this, I think we really need to be clear on what it is, and I think they need to be clear on what it is.
I agree. Representative Newman?
Yeah, I just want to comment in the example that was given, if two people just show up and start asking those questions and doing that, this law would not apply to them because they would have to own a uniform that they didn't wear.
Anybody else?
Follow-up would be, it's not a follow-up because I can talk. It would not apply to, in my opinion, it would not apply to the police because those folks that don't own an official uniform that they should wear, they don't have one, so they wouldn't be subject to the bill.
That's actually a very good point, Representative Newman. So if you're impersonating, you don't have the uniform in the first place, right? So that is clearly a law that this is not going to fix. That's actually a well stated, actually. Anybody else? No more discussion? Representative Murray?
Thank you, Madam Chair. I was just going to add, I believe it was Major Davey who testified that, ideally, so I think the sponsor was trying to address a one-off incident, frankly, that, we don't try to legislate around, one-off incidents, but in that case, I don't think we necessarily have the jurisdiction to force the FBI to respond to this inquiry if they weren't, willing to do so in person. But I think the concern was that if law enforcement, valid law enforcement officials are trying to execute a mission that is not within their purview or execute, responsibilities, I guess, that are outside of their purview, and then holding them accountable for that, which one I don't think should be a Class B felony if that was the case. I think it's more of what should be dealt with is ensuring that there are internal policies to address these circumstances when they arise and that those policies are being followed, which again, I think is a little bit more difficult when we're talking about a federal department or federal agency.
If I'm not mistaken, I do think that there is a bill that we're hearing possibly next week. Actually, it might be next 3:30. That I haven't read that bill at all, but just from the quick little synopsis here, that might be what it's about. And the comment that we've heard a few times about the example that was given, it is very unfortunate when you actually know a person that had a wrong done to them, right? And generally, when you are that person that's had that done, you just kind of want to shout that from the rooftops, like you want everybody to hear about this injustice. And that is unfortunate, and it's happened to every single one of us. But I stand pretty firm. I don't think that this legislation is going to address what that injustice was at all. I wish it did, but I don't think that it's going to. So with that, I believe everybody good? We're ready to go ahead and take the vote? All right. The clerk will call the roll. The motion is ITL for House Bill 698.
Vice Chair Rhodes?
Yes.
Representative Prue?
Yes.
Representative Devoid?
Yes.
Representative Paquette?
Yes.
Representative Saborn Deschwannay?
Yes.
Representative Harriet Gathright? Yes. Representative Muse?
Yes.
Representative Newman?
Yes.
Representative Murphy?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Shear?
Yes.
That's it. 12-0.
Motion of ITL passes 12-0, and we will close the executive session. And we will be in recess until 3:30, which will be our last hearing of the day. What's that? I thank you for the reminder, Representative Gathright. Everybody, that will go in the consent calendar? Nope. Okay.
No objection.
No objection. Thank you. Welcome back, everybody. We are going to open up our final hearing of the day. Open up the hearing for House Bill 640. And we will recognize prime sponsor. Is prime sponsor here for 640? Oh. Hold on, wait. I want to make sure I say it right. Hold on. I know, I wrote it. What is it called? Phonetically? Hooked on phonics. That's what I had to do here. Representative Saborn D. Schwanair.
Good afternoon, Madam Chair, members of the committee. I'm Representative Saborn D. Schwanier. That was really good.
Schwanier.
I thought that this kind of bill would actually be heard in front of state federal relations and not criminal justice, but here we are today. I'm co-sponsoring of this. I know Representative Amon looks like he's the prime. Looks like we got a lot of co-sponsors on this bill. What this bill is about, it's an example of federalism and and the prime sponsor's here now. I'll continue though. It's about federalism and relative to the transparency of federal agency operations within New Hampshire, and what it's asking the Attorney General of the state of New Hampshire to do is to request that in point one, federal government agencies with law enforcement, investigatory, or operational activities in New Hampshire voluntarily provide a list of data as to what they're doing in our state, and then it's to be collected.
Well, thank you very much. Do you want to just go ahead and yield, and we'll let Representative Ammon explain, and then.
Okay. Cool. I shall yield to the prime.
Okay, and then Representative, if you would like to testify on the bill, we'll just have you come back up after he's done, so he can.
Yes, ma'am.
All right. Thank you very much. Appreciate that. Good afternoon, Representative Ammon. How are you?
Afternoon. My printer ran out of ink, so I emailed you my testimony.
I actually just saw that come over, so we do have that. Thank you.
So I'm gonna cover what was in it. All right, for the record, Friday afternoon, my name is Keith Ammon, Hillsborough District 42, and I represent the towns of New Boston, Mount Vernon, and Lineborough. House Bill 640 before you is it's a almost identical bill to House Bill 1411 from 2022. That was put in by William Foster, who's a constituent in New Boston. He is the Honorable William Foster. He was a state representative in that period. House Bill 1411 passed the House, so an almost identical bill to this one, passed the House on a division vote March of 2022. The vote was 204 to 134, so a pretty good majority. It went to the Senate, and the Senate ended up not passing it. So what I did was I looked at the Senate testimony, and I made some adjustments to the bill based on the objections that the Senate heard. And that's House Bill 640, that's before you. House Bill 640 directs the Attorney General to collect specific data from federal agencies operating in our state, including the number of facilities, staff, surveillance operations, investigations, warrants, arrests, refugee relocations, and deportations. This information would be published quarterly in an aggregated and anonymized form to protect privacy. A public website would feature searchable database, quarterly summaries, and annual reports, ensuring clarity and accessibility for the public. So this bill is about transparency and shedding light on government activities improves transparency. It improves the citizens' relationship with the government because we can see what they're doing. We understand to some degree what they're doing. So it upholds the public right to know, empowers citizens with essential information, fostering more informed and engaged community in New Hampshire. I want to note that the fiscal note on this bill differs with the fiscal note from House Bill 1411 in 2022. House Bill 1411's fiscal note was indeterminable. This fiscal note suggests that this bill would require 3 positions for $230,000 a year. So given the bill's scope, this estimate to me seems unreasonable. And I would recommend that this committee request of the Department of Justice to provide a detailed explanation for the investigative, paralegal, legal assistant, and attorney that they claim this bill would require. So, just in conclusion, House Bill 640 would be a prudent measure. It aligns with New Hampshire's tradition of transparency. It would equip citizens with knowledge and strengthen trust in government. And I urge you to support this bill. It represents a vital commitment to our democratic values. And with that, I'll take any questions.
Representative Shear.
Do we, the legislature, the New Hampshire legislature, have the power to order the federal government to do anything?
Yeah, this is not an order. This would be a request. And part of the report would be whether they gave us the information or not, right? So
Okay.
that would be part of the report. Thank you.
Any other questions?
And when I walked in, the end of the bill talks about the report would go to the State Federal Relations Committee. And so that committee, I think, would be the appropriate committee for our relationship with the federal government, but they would be informed about activities. Thank you.
Thank you, Representative. I was just making a note of the fiscal note that you were talking about. All right, I don't see any questions, so thank you very much for coming in today.
Thank you. And for the clerk, I emailed my testimony.
Hold on one second, because I think the clerk just raised her hand. She does such a great job. We don't ever want to not give her way.
Thank you, Madam Chair. I was just going to ask, and I might be missing it. Is there a frequency to when we're requesting the report?
Yeah, so House Bill 1411, which passed, was monthly, and this bill, it's quarterly. So we reduced the frequency, which...
I see now.
Yeah.
Thank you.
Yep.
We're good? All right, thank you very much. Anyone else? Bill? Is there anybody else here? Sir, did you want to testify on the bill? Okay, if you're welcome to come up. If you could just make sure you fill out the pink card though, before you leave so that we have it for our records. If you could just please, when you sit down, just identify yourself and we'll take it from there.
Push the button on the mic.
Yeah. You can bring it closer to you as well if you need to. You can just slide it right up. Then you don't have to.
I should need that, or I should know that. My name's William Foster. I'm from New Boston, New Hampshire. I am the former rep that wrote 1440. And I wanted to testify today so you guys understand where this came from. When I got into the legislature, I was assigned to the Foreign Relations and Veterans Affairs Committee, and I was also speaking with one of my constituents who talked to me a little bit about the limited amount of knowledge that we have in the state of what our federal government is doing. And so I started going down that rabbit hole, mostly because I wanted to find out more about what our federal government's doing so that I would be more useful with foreign relations or with federal relations. As I went down that rabbit hole, I quickly discovered that we have extremely limited knowledge of what the federal government's doing, that it is not centralized, so that in order to get it, I have to literally go and ask each and every agency in the federal government for that information. And that because of the supremacy clause, they are under no obligation to give me any information whatsoever, or they could give me limited information and not include everything. And so in thinking of, well, how can we get more of that knowledge, because in reality, the relationship we have right now in the federal government is one way. We have no idea. And it's not just us, it's not just you as your representatives of your districts, but it's the Senate, it's every bit of our state government, all the way up to the governor. If the federal government doesn't want to tell you, they don't have to tell you. And I thought that was unfortunate, and from a completely non-political standpoint, that's unfortunate. Because, yeah, as representatives, we want to try to, folks want to try to do their best to represent honorably. And so you would think that as a representative of the people, you would have nothing to hide, and therefore, hey, let's have transparency, because transparency develops trust, and that's something that's really lacking in our government right now. So I started looking into it, but there's very little you can do. I put together 1440, and I did it on a monthly basis. My goal wasn't to infringe on any operation they're doing or expose anybody's personal data or any of that. I literally just wanted to know what they were doing so that we could better plan at the state level. And so I put it together because, no, we can't force them, but we can do one thing, and that is ask. And so I thought, well, let's ask them for it. Now, they don't have to give it to us. We're not going to be sure that they're giving us all the information, but at least we'll get some data points. And if they say, we don't want to give you anything, that's a data point also. I don't think that the vast majority of people in the state understand the fact that they don't need to tell us anything. And you may like the executive branch that's in power right now, or you may not like the executive branch that's in power right now. Either way, they don't have to tell you anything. Transparency to me is very important. As I say, it certainly grows trust. It allows us to see what folks are doing. Yes, we can ask them. I think we should ask them, and I think we should centralize that information. I'm hoping that this begins a discussion of just how much the federal government is telling us and what it's not. So we could possibly get transparency between the two. I think it would be much more efficient if states knew what the federal government was doing in them. So I put it together. Keith came and I talked with him, and I thank him very much. Or I should say, sorry, Representative Hammond. I thank you very much for bringing this up. It did pass the House. I had some family issues, and I was not able to walk it through the Senate the way it should be, so it didn't get through. I don't think that this is a partisan issue in any way. I want to know what the federal government's doing no matter who's in power. I want to know what effects they're having on our state. Are they doing things that we should be doing instead of them? We can't answer those questions. And will this solve that problem? No, but it is a very good step, a very small but good step in the right direction of being able to say, hey, what are they doing? And the information they share could become very useful to you folks as representatives of the people. So what I'm asking for is that you pass it through committee as ought to pass. I would love to see it be something that is supported by both sides of the legislature. I think transparency is a very good thing for government as a whole. And I think it would be a good way to start building back some trust in it. So that's my testimony. Any questions?
Thank you very much. Representative Newell?
Thank you, Madam Chair, and thanks for taking my question.
Sure.
There are a couple of things that I just wonder kind of what it would look like in practice. One thing I know, there's data that I like to follow, particularly overdose rates and things like that, because that's something that I'm, passionate about. And I know that a lot of times those things have a lag with them. So doing something quarterly, I think it might be difficult in practice to have up-to-date numbers. So even if you are reporting the numbers, you'd still be reporting on probably 2 quarters ago or something like that. But, you know, a couple of things, but I was just wondering what kind of feedback you got from the Senate and what kind of things were addressed in making the new, in coming up with the new language.
As I said, I had some family issues. I didn't get feedback from the Senate. But what I
Oh,
can tell you is
gotcha.
this, I did put it in as a monthly thing. I thought that would be doable. In reality, it's a list of questions, so it could be submitted by the different, we have a lot of agencies in the federal government. And there's 72 of them that have full-time armed people that can come in, conduct surveillance, serve warrants and arrest people without having to tell a single person in our state government about it. So, I put it in there at a monthly thing. The other thing you'll notice about the questions is all the questions are, what did you do last quarter? Because the second you say, what are you doing? They're going to fall behind we don't discuss ongoing investigations. We don't discuss ongoing cases. We don't discuss our methodology. So it gives them, if you try to ask them for current stuff, it will give them an excuse not to give you anything.
Can I ask a follow-up?
You sure can.
I think some of these things as well, I would assume, and I know in some contexts they do, I would assume probably most, they would coordinate with local police, with local law enforcement. Have you had any luck in discussing it with local law enforcement, and have you gotten any feedback, or state police or any other?
Well, no, and sometimes they do and sometimes they don't. They are not required to discuss it with local law enforcement. They're not required to tell the Attorney General of the state what they're doing. They can come in here and do whatever they want and literally go away. And if you ask them about it, they can say, we have no comment on that. And it's legal. And I think most of you know that. So,
Well, thank you.
do we want to change it? I do.
Representative Murray?
Thank you, Madam Chair. Just out of curiosity, do you have an idea of how likely these agencies are to comply with these requests? Because I guess my concern would be if we put this in statute, you know, that the Attorney General has to do this on a quarterly basis, and if they're not providing, you know what I mean, like just repetitively.
Well, if they're not providing any information, that's a real quick data point for them to enter. No response. All it shows is, hey, this agency has never responded, or they haven't responded in the last year or 2 years or whatever. So I think that if they don't respond, it reduces the workload to almost nothing anyways, but at least we have that data point. Right now, I can't tell you how many are going to respond. It's never been tried, and we don't know. I know that you get a assortment of responses if you reach out to individual agencies, and there's a lot of agencies, so we wouldn't know.
Follow up?
I know you've said that there are a few times. Do you know the number of agencies?
Not total agencies,
Okay.
no. I know that there's over 70 agencies that have full-time armed
Okay.
agents that can operate within your state without having to say a word.
Yeah, just thinking about the time it would take to request all of that,
Exactly.
you
I
know.
think the actual number, I think the last time I looked was 72. So
So if I may ask a question, so basically what you would like is somebody in the Attorney General's office to type something up that says, hey, how many agencies are in New Hampshire, and have them list what those are, and then what they, not what they're going to do, what they did, not their intentions of what they did. And then if they just don't answer, then they just don't answer. Like, do we know who they would even send it to? God bless you.
That would be someone in the Attorney General's office.
Okay.
So,
Okay.
yeah. I just personally, and this is the last, well, not the last, but this is what I will testify to. I think it is ridiculous that there is no centralized point for a representative or a senator, a legislator from the state of New Hampshire to go and find out what the federal government's doing within the state. We don't have that. Doesn't exist.
Any other questions? Seeing no further questions, thank you very much.
Thank you.
Is there anybody else that is here wishing to testify on House Bill 640 that has not turned in a pink card? Seeing none, I will close the public hearing, and we are finished with our business for the day. I believe we're back on Wednesday. He's doing it right now. He's doing it.
Yeah, I'm on my way to a conference. Uh-oh.